onwards, the challenge to section 10C, the matter is fixed before the Honorable Division Bench. It's the Division Bench is sitting of that matter. Lordship, the problem is that some of the issues which have been taken up, I should be.
Is there any interim order?
There is an interim order not to take coercive step in respect of those matters. Those matters which are filed,
Specific interim order.
is not to take any coercive steps.
Can you show me that?
Lordship, on the last official last order, take one day. Lordship, I will get not on the order of the transfer, but for those specific transfer cases, not to take any coercive. So what has happened before the vacation bench, these matters were taken up. Practically, the division bench did not have the time to hear out the entire matter. So on that day, this apprehension was expressed on behalf of the advocate and advocates for the petitioners, appellants, that they should be protected. So, in view of that, that was passed, and Honorable Division Bench was of the opinion.
No, Mr. Chatterjee, if the petitioners who have challenged the constitutional validity of 10C,
Yes, my
they have been given some protection. So those who have not challenged, they should not be placed in a different manner.
Lordship, only one thing I should.
That is why I want to see the order.
I will get. I'm not seeking the interim order. I'm only saying that.
No, I understand. You want that matter should not be taken now. This should be. This should be also.
Expected it would be finished today only.
But I want to see.
Yes, Lordship.
I want to understand the development of the matter.
I have told my learned junior to get it and placed it.
And how far it has reached.
Yesterday, Lordship, the learned advocates appearing on behalf of the parties, petitioners, they have finished. Lastly, Mr. Jayanto Mitra, and senior advocate, has appeared for the last petitioners. They have finished. Mr. Shandal has finished, and other advocates have also finished. And now, Lordship, the state.
What is the issue, ground of challenge to the constitutional?
I was hearing it. The first ground was that 10C is cutting Article 21 as well as Article 13, because when 10A and 10B was inserted, the first point was that 10A and 10B was at the instance of the petitioners themselves, teachers themselves. So it is like their liberty to approach to the authority that I want to be transferred. Mutual transfer or general transfer on mutual grounds, these were given. So far, the 10C is concerned, it is the power of the authority. So power which otherwise could not have given to this authority has been given to them. Now they say that employers, so employer and employee relationship, that actually does not exist here, because the government is not the employer of the teachers. It is the managing committee. They are the employers. Now, that is one of the ground, and there are other grounds saying that retrospective effect of 10C, that has also been argued. Whether this 10C can be could be given retrospectively by changing the service conditions of a teacher.
Was there service condition?
There was no service condition. Transfer was not a service condition because they were appointed by the managing committee.
Chatterjee, is the legislature is not competent to struck down 10A and 10B?
They are competent also. They are competent. Legislature has power. Even the judiciary has the power. Judicial review. If it is challenged.
In the case that it is not even the case of anybody, that whatever right they are claiming, teachers are claiming by virtue of section 10A and 10B. Maybe if 10A, 10B and 10C, 10A and 10A, 10B contradicts or rather offends the 10C offends 10A, 10B, right under 10A, 10B. Legislature is not competent to struck down 10A, 10B to introduce a new provision.
Legislature is competent. That's why I should place the position of law, correct position of law. There is a presumption in favor of the legislature.
It reflects that homework is less. They should.
For making the law. Yes, that is the problem. That is the real difficulty. Even Lordship, uh, even suppose if we
What is the ground level? Now, some teachers are sitting idle in a student place to school. Some schools are unable to run, unable to provide.
the
Can you conceive of a situation? Is a school having 2,000 students, no mathematics teacher?
that is why, Lordship, the
Could you send your son to that
policy,
school?
national education policy has dealt with those situations. When I will be arguing, Lordship, I'll place that policy. It says that where there is a
Tell you what is troubling.
yes,
The teachers are espousing their right. They are not even thinking about those children are coming to school. Forget about the city schools.
the
Think
teachers are
about the
thinking,
schools
but the
of the
question
village.
is, it's a question of policy, Lordship. If I am allowed to say this language, this is the policy lacks the rational approach that could have been if the government uh, would have referred to this national education policy, and particularly this transfer regarding the teachers. They say that it should be avoided. It should be avoided. In that case, Lordship, the other ways of appointments and the inflow of the teachers should be ensured. This state, what has happened because of the all these rate taps in the appointments for last 7, 8, 9 years. In case of the schools, this particular situation has been
You
propped
do
up.
service matters. What is your concept about the order, challenge to the order of transfer?
Lordship, your Lordship's view is absolutely right. Even considering the last Supreme Court decision, particularly these observations of Chief Justice Chandrachud also, this cannot be considered as a right of a person. The authority may consider. The problem is here, these rights is emanated from the existing service conditions of a service. Now, when the School Service Commission was introduced, was created by virtue of 1997 Act.
Understand. These are the technical issues are coming in the way.
Yes, madam.
And I've heard, Mr. Cherry, you can inquire. The ESI Corporation has issued mass transfer. You know what is the problem? I know because one of my friend works in ESI hospital. Local language is a must. Knowing local language is must because the ESI doctors will be treating the laborers from the local of the state. Now, the transfer policy has been framed in such a manner, all South Indian doctors are coming in Kolkata and Kolkata's and Bengali doctors are going in South India. Think of a situation. And no one is challenging or everyone knows somebody says that I will voluntarily take it if it is not going to suit me. Now, I find that this is the situation, you know, the ground level situation. Come out of your area, find out the schools which you saw with full student strength. What is the number of students there and how many teachers are there? What they are doing all
Even
the whole of the day.
That is exactly my point, and that is why, Lordship, if your Lordship take these en masse transfer uh, case to case, if your Lordship examine, your Lordship has found that how impractical their approach was while transferring the teachers. There are the districts, there are vacancies in number of schools, there are
possibly there is a scope to give a representation, and there is an authority who will consider your representation.
That is
that is there possibly in the policy itself or in a circular over there.
Yes.
So whatever defects in the circular, that has to be removed. And case to case, a particular teacher may feel that may find out. There is one case I found that a physically challenged teacher has been transferred to far away. These are the case to case, but challenge to the policy itself. If these teachers say, I will not go, it is my right. This is very difficult to digest.
The only problem is, Lordship, if today the 10C, the constitutional validity, is decided in favor of the legislation itself, the amendment itself, then Lordship,
individual cases
has to be heard.
Of
that
course.
Your Lordship's court is open for that. If it is held to be ultra virus,
then it is a problem.
Then also there is a problem. If it is held as intravirus, Then also there is another question your lordship may consider. That is the question of applicability of retrospective application of this law.
So this issue, if it is argued, if it is already argued before the division bench and division bench gives any returns
So far,
any finding.
So far I recall the Honorable Division Bench said that Honorable Division Bench will be, while answering to these issues, will confining themselves to the issue of constitutional validity
Only.
because even I had few matters which was before the vacations, which were listed before the court number 22, before Justice Roy. And Lordship, those matters were released by Justice Roy on the ground that since these matters are pending before the Honorable Division Bench, this bench is not inclined to
This
take
of
up
course,
the
of
matters.
course.
Thereafter, those matters were tagged with the matter. But I said, while making my submission, I said that in my applications, I have not challenged the constitutional validity of 10C. Apprised by my submission, the Honorable Division Bench was of the view that yes, if it is not challenged, it should be detagged because we prima facie forms the opinion that the reference has been made before the Honorable Division Bench by the Supreme Court. This is a case where reference has been
Possibility of
made.
the Honorable Chief Justice.
to
Some of the matters
bench
were
has
thought
to
to be was prayed for assignment.
assignment.
And the Honorable Chief Justice expressed that you approach the appropriate bench, and if the Honorable
There is
Justice
a only reference has been made to only one question, that is the constitutional validity.
which
of
is the
section
matters
10C.
you wanted? What are the matters?
My lord, 6 to 12, and thereafter,
Very
Lordship,
well. All transfer matters is adjourned for a week.
for a week or Lordship, for a week or 10 days, Lordship. That
Yes. True.
My item number is 13 and 14.
All in block.
For a week.
এগুলোকে আমি অর্ডার করতে হবে।
Okay.
You need not from 6 to 26.
Transfer matter গুলো সব
Any matter of this block bunch relating to transfer in the list? Huh? No, no, no.
Transfer matter matter 6 to
10, not 10C. এটা 26 এ করে দিন। 26 June, Mr. Chatterjee.
by the state for the time being. However, it will not prevent each of the petitioners in the event the order of transfer is issued by the authorities to join the transferred school without prejudice to their rights and
No,
conduct.
this is not coercive.
This is not coercive if they want.
No, no, it is not coercive. What I intended that in default, the clause in default I intend to add to this order will be considered to be breakup of service or discontinuation of service. That is the coercive one.
That is,
But joining is not.
that's alarming. Everybody was like breakup of service.
Very well, individually, if you can convince me that this is not a fit case or the the balance of convenience and inconvenience in transferring is in favor of the petitioner, then it will be reconsidered. Very well.
We shall satisfy your losses individually.
Inclusion Monday. Inclusion Monday.
no, not inclusion, for release.
26.
But I seek for release, but item number 272, it's a hearing matter. But may I go before justice?
272.
Monthly list of the monthly list.
Very well, wait. Now, 26. Call the list.
Lordship, one matter, Lordship, this was taken by your Lordship on 13th March, and there was a direction for affidavit of opposition. Opposition has not been given by them. Now, Lordship, this is an upper primary 2014 matter. These trained candidates are seeking the upgradation of their marks, the score. This matter, Lordship, should be listed.
Relating to 2016.
2016.
Monday.
They have opted.
Inclusion Monday. Every inclusion Monday.
But then
কি হলো? ওটা 272 ও কি বলছে?
monthly list item number 272. তুমি আছো তো ওটা রিলিজ করাবো
আমি আছি
হ্যাঁ ওই যে সিসিএল চাইল্ড কেয়ার লিভ
কেন হবে
হিয়ারিং বেঞ্চে চলে যাবো এখানে তো হিয়ারিং হচ্ছে
এখানে
Justice Bharadwaj is taking exclusive hearing matters. So, my lord, if I my lord, pray before your lordship, my lord, Mr. Basu Malik is there for the state.
No, why? Exclusively, my determination is 2023. Are you
Yes.
suggesting as soon as it goes out of the motion stage, it will be before the hearing bench?
No, my lord,
If you interpret, I'll be happiest person.
my lord, two honorable judges are taking hearing matters. So, my lord, may I take my chance?
You don't think it is a hearing matter?
Yes, affidavit has direction for affidavit is there.
There is no such direction of hearing. I
Doesn't
don't
want
think
to
so.
do it here. Is it a transfer matter?
No, child care leave. Child care leave.
Child care leave.
Yes, my lord has directed the other side to file affidavit. I have filed my affidavit.
I'll
of reply.
consider when I'll be calling that. If
Then
I
will it-
cannot take up this for 2 weeks, then you renew your.
Very good, very good.
My lord, item 6 to 16 lordship
26th.
26 my lord.
Save this.
No, but that is
Policy.
going on. So instead of 26 my lord, let it be in the July because it would be continued my lord. It would be continued. That's what I'm saying my lord.
It continued, then Millard order has to be passed, Millard, it will take
Yes,
some time.
very
for us
well.
now.
Ask Mr. Chatterjee. Ask Mr.
I will inform Mr. Chatterjee. I will inform. Super.
Millard, we shall.
Monthly list করলে কি হবে?
That's better my lord. I think my lord,
এটা order করতে হবে?
it would continue my lord.
Monthly list করে দিন। July, inform Mr. Chatterjee.
I will. একটা order হবে না?
Will there be an order? Millard?
সই করতে হবে অনেক। Call the item number 1.
Obligation.
5 আছে 1 3 আছে
Item number 1.
But I'm for the petitioner.
10C.
No, my lord. The matter pertains to at the time of admission of this writ petition, my lord. The Honorable Justice Mantha had been pleased to pass directions for my lord within 6 weeks. For my lord, because my lord, the wife has come before your lordship, the husband is a,
Within 6 weeks, what will happen?
my lord, what has happened, my lord? The
6 weeks. What was the direction?
direction was, my lord, to exchange of affidavits. Because, my lord, the wife has come before your lordship with a plea that she has not been given the subsistence allowance of her husband. The husband has been, allegation is against POSCO Act with a student or something like that, my lord. So
Why
in-
the wife has come?
wife has come because, my lord, the subsistence allowance.
There is a POSCO still pending.
Yes, I've said so. I've said so. Husband,
Wait.
31/1/2020. The husband had been arrested.
No, unless why the wife has come?
Wife has come because the husband is not being paid the subsistence allowance.
Wife is living.
Yes,
Husband
but it
is
is-
alive.
My lord, kindly appreciate.
I believe is in custody.
This is, yes, he's in custody. My lord, kindly see the
But
rule.
the application will be made by wife.
No, wife has, because of the right to
Legal
life, my
ground.
lord, she is unable to survive.
I
because
fail to understand. It is her part of what is the right he has accrued on for his service. He has to apply.
My lord, he is alive. He has to be paid the subsistence allowance
Why the wife has come?
because he is not being paid.
What is the right of the wife to come to pray for the?
My lord, right of the wife is, my lord, she.
I
is-
don't understand. What is Mr. Bose?
No, that has
explaining?
been,
Are you
admitted.
appearing in the matter? What is what you will say? X is the employee, X is in custody.
That the man who is really aggrieved in the law, Miller, that is the gentleman.
He's,
Yes,
Number one.
wife may be beneficiary of the subsidy.
Yes. but he's in detention.
But
He cannot execute a wakalatnama.
My lord.
Some person cannot affirm on his wife cannot affirm on his behalf.
yes,
The wife
he-
has come on that behalf also.
No, he cannot file.
Wife
He can, she can at least file an affidavit in favor, he can represent.
Wakalatnama has
the
been
husband.
executed by the husband
You go to the custody, get the wakalatnama.
and the jailer will
That is-
hand over the
that
Miller.
is not-
That is what
My
exactly
lord,
the procedure.
processual law has.
I don't know. Satisfy the maintainable and the instance of the wife.
The-
I don't understand what
This is
kind
the-
of,
This is the order of Justice Mantha.
forget about
My
that.
lord, there's a coordinate bench.
Forget about that. The question of maintainability at the
Yes.
instance of the wife. Satisfy me. Because the husband was the suspended teacher, he is still in custody,
Yes.
subsequently he is not getting, he cannot file. The wife can affirm the petition, can represent him in there, but not in her personal capacity. This is my view. What do you like to say? No, I will not going to. Why this petition should not have been entertained?
My lord, it is not the family pension that I agree.
Husband is still alive.
Husband
He
is still
can
alive.
pursue his
but-
cause. He is in custody, is no bar in pursuing his own cause.
My lord, there are some provisions.
Yes,
There are some provisions in law, my lord, under Article 226 or 227. My lord, when any person
hand
can
is your
file,
problem.
any person, then I will come.
Your hands is your problem. Both the hands are your problem.
My lord, there is under
Why
226.
didn't you take this? You appeared in this matter. Why didn't you take the point of maintainability at the instance of wife?
That I said, Millard, the school, my school is, Millard, so far as I am concerned, the gentleman, the teacher was on lien. Now, Millard, lien expired on 20th January 2020.
He has expired.
Lien expired. Lien.
Oh, lien expired.
Now, Millard, I said that he expunge my client from this proceeding because the DI has not approved the subsequent lien. Lien is not a matter of right. Unless and until the lien is approved, no claim stands against my client. He came to my school on a lien from a different school. Now, lien expired. Now, Millard, on 20th January,
The original school is
it's a party. Original school. Now, Millard, the approval is at page 29. Page 29 of your lordship's brief. I said, Millard, so long as he was with us,
First of all, what is your opinion regarding Mr. Chatterjee, you are for the state? How do you see about the maintainability of the writ petition?
Your lordship raised the point correctly, because the wife of the petition, husband of the petitioner, he is in custody. But he can execute the Vaglat now.
He can execute, he can file,
Yes.
only the wife,
Can.
a code of civil procedure, wife can.
Representative capacity.
Representative capacity recognized by the court itself.
He can also make a representation before the competent authority. For
Ah.
release of,
Substitution
evidence.
allowed.
Yes, they have, we have done, it was not
But
released.
personally, she can.
Not the wife.
Personally, she cannot.
But she,
Then let us, you address on the, I'm fixing a date. Let us the maintainability be decided first.
20th, I do পরে ও রথের দিন ও আচ্ছা আচ্ছা ভুলে গেছিলাম রথের দিন না তো
No, not the thing.
Two things. Lien has expired. Mr. Bose's client has no role to play here. Only relevant school is the school
Yeah,
where you
this-
were attached.
expunge me from the proceeding.
So unnecessary bringing that school is not
so
necessary.
that school is already, the deduction is upon that school.
Which school?
Rasululpur.
Millard, may I give the
আমি
picture
রসুল্লাহ।
itself? I have
আমি মেদিনীপুর
date wise.
মেদিনীপুর
I am the school of
Yes,
earlier.
the deduction is upon.
Let me clarify. I have got all these dates.
তুই এফিডেভিট করেছিস
বলে দিচ্ছি। The Ashutosh Mondal was the assistant teacher of my school. 2000 appointment.
29
AHM 2015. He made an application for headmaster. Appointment letter issued. He got released to be joined of my learned senior friends clients school, subsequent school. We have
How is it transfer? Is it?
no, by way of separate proceedings.
Headmaster.
Headmastership.
Oh,
recruitment
headmaster.
2015. Now, my lord, he has got release order on 22nd July 2019. We have given him. Now he made an application. He joined subsequent date, 23rd. Up to my lord, 23rd of 22nd of January, he was the employee as headmaster of that school. Just few days of that 22nd, but he committed that offense.
Alleged offense was committed while he was
In
serving
his
that
school.
school, his school.
Yes, he was. In the meantime, he made an application for extension of lien to my school.
That was pending.
That was rejected by my school.
Oh.
No extension. Therefore, he was not in an extended lien employee.
Office.
We of
Consequence is he will be constituted as a, or constituted.
parent
teacher
school
of- no.
parent school
Yes.
If the
parent
lien-
school
lien is to be issued by my school, then yes, I have given you.
You have not extended that
I
lien.
have not extended.
then
We made an application before the board itself, my learned friend client.
ওকে অ্যাপ্রুভ করেছেন
Board rejected that lien. Therefore, that is the situation now.
No, the
Then-
consequence is,
Hmm.
in which school, of which school he is the teacher?
Now, last time he was the employee of that.
No.
Last.
Nah.
बोलते दाओ ना.
Mr. Viswas, according to your interpretation, of which school he is a teacher?
According to my interpretation, that he is the lien.
He is in limbo
Yes.
between these two schools.
Between the two. And at present. Because lien was not
Mr.
extended.
Chatterjee,
When he was the headmaster
Master,
of Paschim Midnapur, at that point in time, the criminal case has been initiated.
so will be considered to be teacher of which school?
Because my lien has not been expired, 2 years lien is necessary. She is entitled for 2 years, but he has not extended the earlier school.
Mr.
has not
Chatterjee, I fail to understand of which school he will be treated as a teacher as of date. Suspended teacher.
Do not listen to any one of us, Milord. Kindly seize the record, 29 page of your lordship's brief. That is, Milord, the additional district inspector schools by his memo dated 21st August 2019 clearly says that the lien was approved from 23rd July 2019 up to 22nd January 2020. Thereafter, thereafter on 6/2/2020, Rasulpur High School, Mr. Biswas's client said to the President Managing Committee of Bosantpur Jhareshwar Pani Bhavan, that is my client, I would like to inform you that your application for extension of 6 months more has been discussed elaborately in the meeting such and such, members present, and application for extension of lien is not granted. That means he is back to the parent school. That is his school.
In such situation, is there any rule or circular to
Milord,
cover this situation?
no, Milord, the lien, the moment they say, because it requires approval of the GI,
Natural corollary is this. You have
natural
moved from-
consequence.
Moved from this place to this place for 2 months, 2 months expire, no extension, you will be considered to be in your.
Because,
original
because
place.
Milord, the logic is,
Understood, understood.
yes.
The substance, he has applied for the getting this, what is that? Subsistence allowance to which authority? You have applied to whom? To get the,
They board for me.
DI.
both the schools under the same DI.
No, no.
Jharkhand.
I am
She
under
made an
Paschim
application
Mednipur and Nodia.
She applied for to whom?
Page 90.
Paschim Mednipur.
Page 90th, 20th January 2022. And we were not informed of the
Mr. Bhattacharya, you applied for your subsistence allowance to which DI?
Paschim Mednipur.
93, page 93. Even
Page,
Russell-
you tell me na.
Rasulpur High School.
No,
That is
which
the
DI?
teacher in charge.
Milord,
Because
I tell
we
you,
were not
Lordship,
informed
pursuant to the direction of Justice Mantha, he is getting Milord subsistence allowance.
from
It
Russell-
is by from Rasulpur district Nodia. Now it should continue.
His school, his school.
Yes, because
It's Mr. Bhupesh says, this DI who is now providing
Nodia.
the subsistence, the school of Mr. Bishas situated within this jurisdiction of
Yes.
that DI.
Yes.
So you are out of
I
picture.
am out of, kindly expunge my name. That is.
That is your prayer. Now you are getting this. Order has been passed. Now a question has cropped up regarding maintainability of your
Your lordship can
reputation.
always exercise under order 1 rule 10 to substitute, because the payment is being made in a joint account. It is not my own account. This thing, it is not being paid in my name. It is being paid in my husband's name into the joint account.
This is not a case of order 1 rule 10, sir.
Your lordship can always
This
exercise.
is the
even
case
if-
where you must have demonstrated your cause of action. Say, supposing a power of attorney files a suit in his own name, can he? Can he?
No, a power of certainly a power of.
Can he?
No, the
He has
wife-
to file a suit in the name of principal,
yes,
right?
the wife
So
would
what
have
is
signed
your
the-
status? What is your status? You are the nominee or you are expunged. Go.
My lord, wife can file under name of her husband also, my lord.
Yes,
By
that
the
can.
pen of wife.
Yeah, absolutely.
That may be a technical error, my lord. on the
No
part of-
technical, this
Not
is not
kindly
technical,
appreciate,
this
my
is
lord.
not technical.
This can be rectified, my lord. It is not a,
You can
This is which cannot
rectify
be
it by file a fresh writ petition. Through your client, means your client should have been the husband of this petitioner. Right? Very well. I'm adjourning it for 7 days. You take in the meantime, whatever decision you want to, you may argue regarding maintainability or you may withdraw and file a fresh. It is up to you. Now, so far the main issue, your grievance is, let us assume that husband is espousing this, his grievance. What is your grievance? They are not providing you the
they are
subsistence.
providing only 30% of this thing as per Justice Mantha's order, not the exact amount which is as per the law.
As per the rule, you are entitled
Yes.
to. Now,
Because
any
some-
DP is initiated, disciplinary proceeding initiated.
He's in custody, so he's under suspension. And he's in custody, matter is continuing.
So is there any difficulty in initiation of any
No,
discipline?
DP will not improve the case. Because your lordship.
You need not see about the DP. What is required to be done by you? What is required? Who will initiate the DP?
Board.
So don't think that what is required to be done, what is the beneficial. Do your job.
Lordship. I think maybe it has already been initiated, as strict instruction, and if not initiated, it will be.
My lord,
90
I think
What is the FIR?
disciplinary authority has already been initiated, my lord.
Disciplinary proceeding initiated.
Initiated, my lord. Because my lord, the disciplinary authority wrote a complaint to the president of my school, Bosantupur Jhareshwar Bani Bhavan, complaint against Sri Ashutosh Mondal, headmaster, Bosantupur High School. Enclosed, please find over the order passed by the president, West Bengal Board of Secondary Education, on the complaint against Sri Ashutosh Mondal, headmaster. For your information, it is issued by the disciplinary authority, my lord.
You inquire. ठीक है, submit a report.
Subject to correction, his school may not be expunged now because it has happened in the school premises of him.
No, cannot be.
Because all these things are to be
Exactly.
given to the
Necessary,
board,
necessary party.
student of that particular school. And there are no
Where is the FIR? Where is the FIR?
FIR. FIR is that page.
POSCO case is pending, my lord. Minor.
FIR is page 31 to 71. 31 to 71.
FIR is page 31. পয়সা দিচ্ছে না।
Yes, এটা দিয়ে তুলে দেবো।
আচ্ছা।
বিষয়টা কত থেকে দেয়? এই 20 সালেটা তুলে দিই।
জানুয়ারি 1।
ওই আওয়াজ চালিয়েছে। গাড়ি থেকে তো তুলে নিয়ে যাচ্ছিল তো মেয়েটাকে রাস্তায় ধরেছে। এটা তুলতে হবে।
হুম। 9-10 9-10 9-10
Urban concept.
with গোরাচাঁদ সামন্ত গোরাচাঁদ
Urban concept.
জিসি সামন্ত
What is the age of your client?
Pardon?
What is the age of your client?
My client, at present, my lord, she's having a son in class 12. Over some, she's my lord aged about 48 years, 49 years.
সেই
The son is now in class 12. He has to give his examination, and if he's successful, over 21 lakhs is dues from the government. So, my lord, unless the order is
When he was taken into custody?
on 31st of
30th
January 2022. 2020.
2020. In the FIR it is dated
Till date, no disciplinary proceeding has been
No.
initiated.
My lord,
3 years.
my lord,
4 years.
kindly concede.
Only one letter.
Well, it is habitual, my lord. In earlier school, this thing happened.
No, these are out of the context.
Rashulpur High School, my lord,
And
40
one thing, and
In your school, this incident.
that is why his
Yes.
DN was cancelled by my client. This is a letter, kindly see. It
that
is
it is
addressed to me.
habitual, my lord.
My lord, this is issued by
Why
the
is that my lord, regarding extension has been discarded by the managing committee? Kindly see that letter itself. That is why it has been written, giving to the board.
Yes, ma'am,
And
they
there are
should have
next page-
given it in the affidavit
Kindly
as per
see.
the direction
Yes,
of the
I shall,
Honorable
I
Court.
shall. Conduct.
এরকম বাপের লোক রাখা উচিত না, সত্যি কথা।
A proposal. And thereafter 2-page letter, board has rejected that extension. Therefore, he is now in the midway of the 2 schools. Because in the meantime, that post has been filled up by Utsos itself.
I feel pity for the petitioner, the wife.
And if your lordship kindly come to page 73 itself,
That is the reason we have
title
come.
letter.
The son is not aged in class 12.
অপবাদী দিয়েছে।
When he filed the writ petition, he was in class 11. Tomorrow he has to go for high.
Her son has filed a writ petition, the wife.
My lord, kindly come
The
to page
son, I said.
73 itself, the admission of the part of the petitioner. He is her husband has given the resignation letter, either forcefully or not forcefully. It is to be, my lord, adjudged, but it is the admission from the client of BASU's school. দেওয়ার উপরে তো জোরপূর্বক সাদা কাগজ শিক্ষকতার চাকরি হইতে অব্যাহতির কথা আমার স্বামীকে দিয়া দরখাস্ত লিখে সই করিয়াছে। Therefore,
He has tendered resignation.
that is, this is admission.
That will have, I will have to
He
take
will
instruction,
ascertain
my
before
lord.
the lordship.
Whether
You
any,
are filing your affidavits. Why are you so?
my lord, only the issue involved in the writ petition, my lord, all they, she prays only for the subsistence allowance, my lord.
Full subsistence.
Full
allowance, that in
subsistence.
view of the fact
75.
My lord, considering the,
he is in still suspended without any disciplinary proceeding being initiated.
my lord, disciplinary, I think.
No, that has, you have must brought on record.
My lord,
That you must brought on record formally.
It is to be-
Because first of all, whether the wife of the suspended teacher can maintain this writ petition. Secondly, if in the absence of initiation of any disciplinary proceeding, rule provides he has to provide. But if the disciplinary proceeding is already initiated, then possibly he cannot have any case of that nature.
my lord, I think.
The board is the person who can
My lord-
say whether disciplinary proceedings have been initiated or not.
But full substance is not.
75.
My lord, it is written in the memo issued by the
90 days
president of the board, my lord.
Subject to correction, my lord, within 90 days, the disciplinary.
The president of the West Bengal Board
proceedings
of
ought to have
Secondary
been
Education, my
initiated.
lord, suspended him. And he is entitled to get his subsistence allowance as per law.
This is on 6th February 2020.
20.
Rather the teacher's allegation is that he is not getting the amount of subsistence which is entitled to under the rules. If you are agreeable that 75% he is entitled to, grant him and let him face the.
No, not in the capacity of the petitioner. It is the capacity of.
No,
the-
no, but the
Yes.
husband,
That
he
is-
has to.
The board doesn't pick the allowance. It is upon the school who approves.
No, no, very well, the schools.
It's the state which is
But
paying the.
you are apprised that whether you have initiated any disciplinary proceeding or not.
And it is addressed to the DI Paschim Midnapur, not to my DI Nadia.
Well, may I
Page
suggest
73 kindly see.
Let an affidavit in opposition be filed by myself, by him and him.
No, no, in a not maintainable writ petition.
Let it be hard past maintainability thereafter.
He may take the call. He may say tomorrow that I'm taking back, I'm filing it afresh.
It is.
The hearing of the
Subject to
matter
lordship
is.
kindly approve, my lord. Nodia District Inspector School, Nodia is not a party. Well, he is a necessary party.
District Inspector of the school?
Yeah.
Nodia, Roshullapur, Mr. Bas. Mr.
Under
Mishra.
whom I am working, my school is there.
Let us the maintainability point
first
be
class.
addressed first.
Hmm.
If he choose to withdraw and file a fresh application, then he is entitled to an interim order, payment of 75%. I will inquire whether disciplinary proceeding has been initiated, stand of 2 DIs, and I will direct him to expedite the disciplinary proceeding. Pending, get the subsistence allowance at the rate which is admissible according to the
75.
rules.
75.
Adjourn for 7 days.
Okay, good.
Let us meet on the next.
Because only well, there must be direction for
matter
filing
on.
maintainability.
No, only issue of maintainability.
Order be recorded.
Argument.
Very well. Let the matter be listed on.
21st করবে? কবে সেটা?
7 days হচ্ছে কবে আজকে থেকে? Very well, 26.
26 lordship.
26. To decide the maintainability of the writ petition, to decide the issue of maintainability of.
Or instead of 26, let it be a day before on Friday, the previous week.
Because you have any difficulty on 26.
Or yes.
27 করে দেন তাহলে।
27th, I will not be in town. So on 26th, I will.
We'll go to Puri.
No, maybe Ulto Roth. 27th Ulto Rath.
28.
28 will do.
28. 26, what is the difficulty?
Not have to
Oh, ho. Then,
Friday.
then, what is the difficulty from 23rd? He wants to back more. She wants to back more than you. She is traveling on 23rd, then 22nd. 22nd.
I'm deeply.
But we mentioned.
Do we mention maintainability point one? But you will be filing your report, at least instruction.
ওই ডকুমেন্টটা নিন না
হুম।
সাসপেনশন
Then some of us-
মানে
Please,
আমি
okay. Yes, evidence of service be kept with the record. Where is Mr. Bhattacharya? Has left. No, if you think that you will be withdrawing and you will be filing it, mention it earlier so that the matter may be dismissed and you file and you can be interim order can be passed or make ready by 22nd. Make your application ready by 22nd.
My lord, I shall if any opportunity arises, my lord, I shall mention on Monday itself, my lord, whether we'll be withdrawing the petition.
Very well,
my lord,
very
I
well, very well, very well.
এটা করে নেয় উইথড্র করে
একটা
টেস্ট করে
interim
দেয়
order
তাহলে
নিয়ে
সুবিধা
75
হবে
days।
হ্যাঁ সেম অর্ডার উইল বি রিইম্পোজড অন দ্য বেসিস অফ অ্যাপ্লিকেশন
Get to it.
I appear on behalf of the petitioner.
But this is that matter or is a new one?
New one,
No.
my lord.
This is a new other matter, my lord. You are here, my lord.
Age correction.
Not it.
Transfer order has been issued, but
Lord,
huge amount has been taken loan from the school credit
আমাকে একটু
society.
বলতে দেন আমি তারপরে আপনি বলেন আপনি যে
Teacher of which subject?
Teacher of which subject?
Pol science,
Pol science.
pol science, political science.
Political science. Transfer order issued.
this is not a subject matter of the transfer. I say, my lord, that I was initially recommended for a post of an assistant teacher. Then I was recommended in a different school. I had joined in the said school. This is the,
Then what?
I was recommended. Sorry, I'm sorry, Miller. I was appointed in one Khar High School. This is under DIAC Purvo Midnapur. Now then, Miller, I was issued or I was offered the order of mutual transfer. Then Miller, pursuant to this order, I had joined in Banch Pahari KPSC High School on 15/2/2021. Now, this is not the problem. Problem is, while I was working in Khar High School, I had obtained a loan of rupees 10 lakhs from the Employees Credit Cooperative Society. Some amount has been paid, some amount not paid because in the interagnum, what happened is that Millard, I was transferred to the school and another school and the first school and now this is the second school where I have joined. Now Millard, I am not getting, yes Millard,
X school to Y.
yes,
While you were serving in Y school, you took the loan.
no, while working in the X school,
Original school.
I obtained the loan. Now these particular,
Transferred. You have transferred.
I have been transferred through the,
Then from there to another school or this is this.
no, I was only transferred to
X to
one school, X to Y. Now Millard, this particular thing, my lord, just 1 second, Millard, this order of transfer was issued by the West Bengal Board of Secondary Education. There is no problem. There is no Millard dispute with regard to that. A peculiar situation had arisen, which my lords may kindly consider that after I was transferred to this school, that is a X to Y school. Now, Millard, I have to get my salaries for working.
Then Y school will be there. From Y school.
Y school I will be getting because I was transferred from X to Y school. Now, Millard, the Y school takes a plea that last pay certificate and the DI does not, and this particular school
of the second school, that is Y school, which is named as Bashpahari KPHC High School. This Milord falls under the particular Milord DI AC Jhargram. Now, the particular situation which has arisen is that last pay certificate of Khor High School was not forwarded to the DISC Jhargram. DISC Jhargram, although I am working, he is not giving my salary from 15 to 2021.
No, I don't follow. Who is giving you the marsh?
The particular,
Bashpahari or other?
no, the particular Bashpahari takes a stand. I am working, no problem, because this is, they have to act
So
upon the
the marsh is not coming from Bashpahari.
Bashpahari, but it is coming from the,
Your Ashwali
the-
school.
no, the Khar High School. First is
Not-
Khar-
Forwarding your last pay, sir.
last pay
That is your
certificate,
problem.
and kindly see that this particular Milord DI, Milord AC Jhargram, till date, he has to disburse the salary for which I will get it. Now, what I did, as an abundant caution, I have taken out an application. What I am submitting, Milord Lordship may kindly consider. I am submitting that something is due to the particular Khor High School.
Due to
Some
Unless-
amount is unpaid insofar as the Employees Credit Society of Khar High School, that is the first school, X school.
Mm.
It is X school, the Employees Particular Credit Cooperative Society of the X school.
you took loan from your employers credit cooperative
right.
society. Very good.
Now, I have paid some is remaining
Pay
paid.
that.
Now, if the DI, if the second DI, that is the Y school in which I have been transferred, if they release my particular salary, or if they directly deposit it to the particular Credit Cooperative Society of Khor High School, the entire matter will be resolved.
Why
Nothing
DI
will
will
remain.
take step, my lord?
Now,
What is
now,
that? What is that? Who is now credit cooperative has been added as a party.
Milord,
Who is representing credit cooperative society?
Credit Cooperative Society is,
I'm
the Credit Cooperative Society
You
is
are.
respondent number
What is the
8.
total amount due?
7 lakhs.
7 lakhs odd. Now, what is the due salary, amount of due salary?
Yeah, I have Milord to
Well,
my
earlier court
instruct-
passed the order, lordship, kindly go through this. Already, my lord, page.
Milord, I say,
59.
Milord, that thing, Milord, for which I have
The
filed this
application,
present
Milord.
application. This
Page 90.
application I have filed for modification of this order to a certain extent.
Let me see the order. Which is the order date?
That is at page,
90.
in the application, your lordship.
No, in this matter, in this matter.
In this
in
matter, in this matter.
Order date?
19th November,
10/11/2022.
10th of November,
page 19.
page 19 of the application.
কোথায়? হ্যাঁ, application.
10th November order
Yes.
Yes.
Milord, I have filed an application before.
for modification of
Yes,
this
yes.
order. Let us see the main order.
Yes, yes. তোমরা চেষ্টা করুন এই সমস্যাটাকে সমাধান করে দিতে, ওই বিচ্ছিরি জিনিস এগুলো আর আমি কিছু করতে
আমার ঘরে চাপাচ্ছিস।
আমি চা
Wait, wait. অনেকবার বলেছি। Who is the respondent number 4?
What is the DI?
DI of which district?
And Jharkhand.
Puro Midnapur. No, Puro Midnapur.
Bashpahari is in Purbo or Poschim?
No, Bashpahari is the Jharkhand.
Bashpahari is under
Jharkhand, very well. Purbo Medinipur is a relevant DI.
At the material point of time, Puro Vendopur was there.
The hearing directed to be
Purvo
given.
done by the DI.
That you participated, or did you?
Yes, yes, everything I
What is,
participated.
what is the,
Now, Milord, they had passed an order. Kindly see this order at page 17. They say page 17 of this application.
no, in terms of the direction passed on 10th November 2022,
Yes,
there was a direction upon the respondent number 4 to resolve the factual dispute after giving an opportunity.
grateful.
That deal was done.
That was done. Now the DI Milord,
17
page
Page
17
17 of what?
of this application.
order has been annexed, Milord.
Kindly see paragraph 6.
Application, বার করুন।
আছে?
ও যশব ওইটাই পাচ্ছেন না।
17, supplementary affidavit.
আমি আমারটা দিয়ে দিচ্ছি।
Affidavit of service goes ahead. এটা ঠিক করো তো।
Milord, may I, for an abundant caution, may I give it এটা দিয়ে দিন।
ওইটাই তো।
What new thing he has said in this? He has said that he will pay, he will issue.
But that's all.
That's
Now,
order- that's order
what
on
is
court,
the,
Milord.
Yeah,
what
DI.
is the difficulty which is?
But
co-
DI
I'm
should
sorry.
ensure payment and
right.
this issuance of this note. But he has said that what the Justice Roy has said to resolve the factual issue.
আপনাকে করেছে, can one of them, দেখে নিন।
Hmm. So what could be the possible measure the deputy number 4, respondent number 4 could take is that sit with both parties. And what Mr. Bhattacharya is now saying that when you can able to pay the due amount, payment secured, no dues issued, matter ends. But
That's
he
not my
has
claim.
said that he has showed the path that if he pays, then no due certificate can be issued. Now the one order is now standing that you will be paying the amount, no due certificate, and so far last pay, it is already lying in the record you have submitted.
Right.
So how, in which mode you are suggesting? Why these order need to be verified or
I'm getting. Now-
varied or modified?
Yes. Now, Milord, the reason why I am, Milord, suffering, that, Milord, your lordship may kindly take my particular modification application, wherein, Milord, in paragraphs, Milord, I have submitted, just your lordship may kindly consider para 13, page, paragraph 13 of this application.
Paragraph 13.
If instead of respondent number, Milord, instead of respondent number 4, it is modified to respondent number 5.
Why?
Why I say, because there are two DIs, kindly consider. One is the DI
Have you
AC
raised this
Purbo
issue?
Midnapur.
Mr. Bhattacharya,
Yes, Milord.
you appeared before respondent number 4.
I appeared before the respondent number 4. Yes, I have,
Appeared?
yes.
Did you take that issue at the time of participating that
No,
instead?
I cannot, I want, Milord, an effective solution of the
Why,
matter. I do not want-
why the involvement of respondent number 5 is necessary?
No, why I am necessary, because, Milord, your lordship may kindly consider that I want to resolve the issue. I do not want to create a problem.
Respondent number 5 is a
I am not
Jharkhand DI.
getting money consequent
Respondent
of it.
5 is a Jharkhand DI.
I am not getting the money in the school in which I am working, for which
So,
I am,
Listen, I understand. Since Jharkhand DI is the authority to disburse your salary,
Salary.
therefore you want that Jharkhand DI should be involved. because you want my due salaries should be adjusted against that. That is your logic.
Nothing more, nothing
Understood?
more.
He is seeking.
Even
this
that amount, the rest amount may be
Money-
deposited to the register of this
Money-
honorable court.
money is actually lying with this respondent number 5 on account of area salary
After transfer.
after transfer. So he wants that since I am proposing that money be given to the credit society to adjust to liquidate my dues. Therefore, respondent number 5 be involved in
I
this.
do not even want to touch 1 paisa of this
What is
money.
the total amount lying according to your calculation? How many months you are getting? How many months you are not getting the salary?
7 lakhs, more than 7 lakhs. Loan was due.
এখানে আসুন, এখানে
Loan taken 10 lakhs, more than 10 lakhs. He has paid something, now 7 lakhs.
সেটাও মিলন নয়, the instruction is around 18 lakhs. However, that will be calculated by the concerned.
Now, the difficulty is
Yes,
DI cannot liquidate your loan.
Right.
It is your personal
Yes,
liability.
yes.
Only if this amount you are allowed to
The
withdraw.
amount of salary which I am entitled to, that the DI can only calculate.
Wait. Can it be done? The amount which is now in the cooperative society is entitled to recover from the petitioner. To that extent, you release the money. Area salary.
Yes.
But
Yes.
this is loan taken from the school,
You are
not from the DI.
No, I am not saying that.
Mr. Chatterjee, hear it. The area salary to the tune of supposing 8 lakh you release. And on receipt of this, as soon as the loan was liquidated, then only the rest part you will be getting.
Yes, yes.
That was the observation of earlier court, my lord.
Where show the release order was there? No.
No release order already submitted.
No. Area salary.
No, my lordship kindly.
No, area salary.
No.
This matter has, no, that is what? If the DI of Jhargram is directed to release the salary of few months and calculate what is covers 8 lakh.
Rule specifically provides that the no liability certificate should be produced from the earlier school. So what way will a DI? You will take the responsibility upon you.
No liability certificate. You are the erstwhile school.
Yes.
Erstwhile school.
Actually, my lord, there is no relation with the my lord petition. At the occasion, relation has been my lord seized. My lord, actually, but loan is loan is lying
So
there.
far the loan,
Loan is lying there.
can there be an agreement with the cooperative society that you will be, I'm extending to liquidate the amount from 2 or 3 months?
That was there. My lord, the headmaster was entitled to my lord realize the same and to give the my lord to deposit in the credit society. But as the my lord online payment is there, my lord petition has been enjoyed all the my lord money. My lord, no payment has been given my lord, for long.
No, you calculate your dues as of today.
It seems me that all the parties will not, they want that is let the problem be not solved. Let it continue.
No, Mr. Chatterjee, let us see.
My lord, dues I have calculated.
Give me the total dues.
This is the due from that date.
আপনি
And day to day, my lord, what will be there, I have stated also.
This is on 9th November 2022.
There are day to day will increase.
You find the latest and the due what is the amount due?
Multiplying like that, per day, the amount will not, I have stated. And you see, per day.
Per day, I do not want. I want a concrete. If you do not have, produce it in the next date.
No,
What is an amount due as on the expiry of, supposing we are today on 30th June,
Give me 10 minutes time, I am giving. Because
right? On 30th June, what will be the total amount due to the cooperative
I will
society?
give you 10 minutes.
Right. Now, what are the total amount of salary is lying with the arrear salary with the DI of respondent number 5?
Yes,
Right.
Yes,
Now-
I am just 1 second and I'm taking. কত স্যালারি ডিআই এর কাছে পড়ে আছে আপনি কাজ করে মায়না পান ঝাড়গ্রামের কাজ হ্যাঁ 74,000 সেটা কার কাছে আচ্ছা আর 74 যে ডিআইএসি ঝাড়গ্রামের কাছে আছে আর এখন আপনি যে ডিআইএসি পূর্ব মিদনাপুরের থেকে আপনার কত পান AISC পূর্ব মিদনাপুরের থেকে আপনি বলেছেন আমাকে যে আপনি কোনো স্যালারি পাননি, আপনি কত পান?
So total due salary is 74,000.
No, I think Millard, again, these persons, Millard, I say Millard that if required, Millard, your lordship may kindly take them, put to box.
No,
Because why they,
Mr. Bhattacharya, Mr. Bhattacharya, from which month you are not getting salary?
আপনি কোন মাসের থেকে স্যালারি পাচ্ছেন না?
ফেব্রুয়ারি থেকে
ফেব্রুয়ারি কোন বছরে? 2021 থেকে আপনি স্যালারি পাচ্ছেন না। এই কথাটা আপনার বিয়াপে আমি জজের কাছে বলতে পারি তো? From
February
20
2021. What is which is salary amount, take home salary?
আপনার কত স্যালারি অ্যামাউন্ট?
Take home salary.
টেক হোম স্যালারি
18 লাখ।
18 লাখ। 18 লাখ আপনি কি সুস্থ? 18 লাখ আপনি পার মান্থে স্যালারি পান?
74,500।
74,500 হচ্ছে আপনার স্যালারি।
Nervous. To 74,000, if that, supposing 70,000 from which month?
আপনার সব কিছু করা যাবে না।
Jharkhand.
2021, which month?
February.
February 2021. So 74,000 per month. From
Huge amount.
February to March 2022. Calculate the amount.
4,000. 8 lakhs.
So it will cover the due amount.
Yes.
Now, Mr. Chattopadhyay, find out if this amount is released or can be adjusted against the due amount, or in which way. Find out the way.
Basic problem is that government money, when the last pay certificate is not deposited, this salary cannot be released.
That is correct. I say, Millard, let Mr. This is absolutely correct.
No, if this
This
last
last
pay
pay
certificate,
certificate may kindly be issued by Mr. Bhattacharya within 7 days or 2 days from the date of passing of the order, let it be produced before the DI. Then Millard, if Mr. Chattopadhyay takes a kind step so that the matter can be adjusted.
the last pay certificate is, you have already issued.
No, I have not issued, Millard, it is prepared.
So issue it
But
with the
Millard,
condition and calculate your total amount.
total amount, Millard, I am calculating, Millard, that is 7,43,000 something.
ঠিক আছে।
And your due 7,43,000 and almost 8 lakh is lying due
Yes.
area salary. You issue no liability or whatever the last pay certificate of the petitioner. Come with that, come with the calculation.
Yes,
You file an affidavit
I will,
with the undertaking
yes,
that the amount as soon as will be disbursed area salary,
yes.
within 3 days, you will be liquidate the area.
And I will file an affidavit, or I am giving an undertaking to my client to be before this honorable court that this amount will be secured before the Registrar General of this court.
No, why this is? It is a very simple
Whatever
way.
direction, my lord, please. Whatever.
That, no, you come with an affidavit
Yes, yes.
that if at the, from the area salary,
Yes.
quantify the amount. This is my area salary
Very well.
amount is lying with the DI or such and such.
Millard, but one thing I should submit, Mr. Chattopadhyay had very rightly said, Millard, this is the law also that the
No,
last
he-
pay certificate
he-
has to be issued by Mr.
No,
Bhattacharya.
Mr.
that
Bhattacharya's
the
client
matter can-
shall issue with the understanding and with the undertaking that as soon as the money will be coming in your hand,
Yes.
you will within 2 days will be liquidate
Then I will-
all your
I
areas.
can file an
Under-
affidavit
under-
day after, on Monday.
Undertaking with this court. Undertaking with this. court.
Yes, on affidavit.
On affidavit, on
Affidavit.
Monday, I will.
Otherwise, he will losing his service.
I-
He'll be
I-
immediately suspended.
Millard, I
his
will
service.
be
Lord,
giving
if
an
good Friday-
undertaking by way of
Come with
filing
an affidavit.
on Monday.
Come with an affidavit on
Yes,
Monday. You have understood what you are required to state.
Yes.
Serve copy upon everyone.
Millard,
Come on
everyone has the-
Wednesday. In the meantime, effect service of your affidavit. And if he is satisfied with this affidavit, then only I will be directing him to issue the
No,
last pay certificate.
Yes.
And the follow-up actions will be accordingly.
Of course, Millard, I am grateful to my lord. Everyone is cooperating, but Millard, matter is not being.
Millard, let it Tuesday, Millard, so that I
From the
can.
very
give the
beginning,
undertaking.
From the earlier coordinate bench, I have made the same
Yes.
argument. On
Mr.
that basis,
Chattopadhyay
you
was fair. I say, Millard, and And I,
Milord, let it be Tuesday, Milord, not.
No, Wednesday, by Tuesday, by Monday, you will be getting the copy.
I will get copy and I will
You will
take
get
instruction from my
copy.
client.
The claim, should send it to your client,
No.
that this is the arrangement
My
the court
Yes,
is
my lord,
making.
Milord.
Whether this will affect the cooperative society's right in any manner or whatsoever.
I will. Milord,
Place the
Milord,
matter
school is
in the
also
list.
accommodating.
Well,
school
lots
also
of Kali direct, matlab,
yes, Milord, your lordship may pass an order.
No,
Otherwise,
I'm not explaining that. I'm not dictating
No.
on that. I'm not explaining.
the
Mr.
affidavit, your lordship may.
Yes.
affidavit part.
As paid for by Mr. Bhattacharjee, Learned Senior Advocate for the Petitioner. Leave
না,
is
না, দাদা,
granted
এটা
to the
জয়পুর
client.
আমি কি যা বলছি
File
করতে
affidavit.
দেখুন।
Affidavit of undertaking.
Yes,
Stop.
চুপ করতো।
Copy of such affidavit be circulated amongst the appearing counsel for the respondents by Monday. Monday next, matter to appear in the list on.
Hello, school also will calculate the amount which is due.
Of course,
Milord,
of course.
I
I am
shall
not directing you to bring the no, the last pay certificate
I will take
with the, because unless you are satisfied, the affidavit is covering your client's interest, then only but bring it with you
Fine.
so that it can be done in one
my lord. Matter will appear
Wednesday.
Now get
And I will file the affidavit on.
On Wednesday, but you circulate the copy by Monday.
Yes, yes, that will be done. That
Whether
will
I
be
can
done.
take
Yes,
instruction.
yes, yes, yes.
Grateful to Lord.
I'm grateful to my lords.
Lord, grateful. School একটা solve চাই, school চাই।
আমিও চাইছি solve করতে। Will the matter will appear under the heading to be mentioned.
No,
It's not will take
10:30, 10:30.
10:30.
Time di do 10:30. Wednesday 10:30. গেলো? Parties to act on সেখানে জায়গায় ভুল আছে নাকি? Matter to appear. ওহো, থ্যাংক ইউ, নজর করে করুন।
I am for the petition.
দেখি কি আছে।
Your Lordship, I am appearing on behalf of the state. There was a direction to. Adichi, just a minute.
You are for the?
State. There is a change, Your Lordship.
Respondent number 6. Murshidabad. Thank you. What is your reaction on this report?
The Lordship, the simple prayer of the petitioner was to transfer.
I am not concerned about the prayer of the petitioner. I want to know what is your reaction on this? Because the DI has identified 26 schools having surplus teachers. And the petitioner's school is coming within this or not?
No, that school has not come, my lord. There is no name.
What about the PTR of this petitioner's
The
school?
Shaktipur Kumar Mohim Chandra Girls High School.
What is the PTR of this school? You are the teacher of which subject?
History.
Can you give me an idea about the student strength of your school?
My lord, last occasion they have filed 1516. That is page 3, last page.
24 teaching sanction post.
My lord, that is also sanctioned for, and some is wrong, my lord, in this.
Sanction number of teachers are?
Sanction post is 24, but my lord, there is some more teachers, my lord.
Some more teacher means?
My lord,
Sanction strength is 24.
Existing, my lord, sanction strength is 24.
Existing number of teachers?
That is, they have said 14. And there is other para teacher and UA from non-government NGO sponsored teacher, and one is by the local panchayat sponsored teacher.
This is the all voluntary actions. But these are not permitted. Sanction strength is 24.
24.
Now 14 existing teachers appointed by the government. Now 4 out of them, 5 has transferred.
And my lord, one teacher that she has been transferred who applied after me.
I will consider your individual cause, but first of all, let me get the idea of the school.
My lord.
Number of student is 1,000?
15,016.
1,516.
That
Now-
is at last page, my lord, on the
Now, existing staff is 14 only.
Okay.
Strength, now 10 more teachers are necessary. Are you appearing?
The thing is that this petitioner is the single teacher. She is the history teacher. She is the only teacher.
I am not asking you anything about the
Yes,
petitioner. I am only concerned about the school where there is a 1,500 student, 14 teachers are only there, 10 teachers are necessary. Why I have called for this report? So that, see, 126 to 17 teachers, there are 26 schools have been identified with surplus teachers, out of which 5 of schools have already been forwarded
Forwarded to the commissioner.
commissioner.
Rationalization on the.
So what steps commissioner has taken? First, fill up the vacant post here, taking the cue from the
Yes, sir.
rationalization program. Then everything settled, then I will consider her personal difficulty. If he can convince me this situation is really grave, he requires transfer, then only we consider. Otherwise, she has to be here in this school.
My lord, what I am beseeching, my lord, can it be some time be given to us, because yesterday we got the.
Possibly you are only new in the field. You are new in the field. Try to catch hold of the pulse of the court regarding transfer policy. Find out, ask your DI that to give you a status report regarding his move to send it to the commissioner, I want this school, 14 vacancies must be filled up immediately, must be filled up immediately. No delay. Now 14 teachers, and find out what are the details of these 14 teachers, which subject.
Yes, my lord.
Nothing he has spelled out. Earlier report reflects 14 vacancies,
Yes.
right? 6 has been, out of the 6 transfer, what is the total number of teachers now in the
14 teachers.
subject wise?
Yes.
What are the subject wise necessity? Give this detail, not this way.
Yes.
Hmm?
Yes, my lord. I will ask the commissioner also to give a status report because already DI has sent. I will come, my lord, give
No,
us some-
because you have to find out the vacancies of in which subject.
Yes.
Right? Now pick up that these subjects, 14 teachers or whatever the numbers are lying vacant, that this the subject is to be found out, is to be find out from the, you have to find out the subject teachers. She's a history. Keep it in mind. You may have require another additional history teacher if I allow his prayer
Yes.
to fill up. Now, what is your prayer, Mr. Lahiri? From where to where? From Murshidabad to
I
where?
have no choice, my lord, only my lord, to my nearer to my residence. I am residing at North Chobbish Pargona. Even I prayed, my lord, your lordship once desired to transfer me my earlier school. That is also at Thakurnagar, Bonga. I am agreeable to that because, my lord, now, my lord, I have to.
No. If the Thakurnagar Bonga has no student, is a bar job
No,
closer?
my lord, there is a student, my lord, so far my instruction, and there is also vacancy of history teacher. Still now.
What is the number of students there in Thakurnagar?
My lord, right now I cannot ascertain.
Collect all these because these are the relevant issue I'll be considering.
My lord.
Where there is a need of you,
My
you
lord.
may go there. Subject to availability, your subject teacher within the district.
My lord.
Asunto? The respondent number 6, a report on as directed by the order dated May 18, 2023 is filed on behalf of the respondent number 6. Let it be kept with the record. Stop. The report suggests that surplus teachers have been identified in 26 schools of the district, Murshidabad, and out of which surplus teachers of 5 schools out of the proposal of inter-district transfer of 5 out of the said 26 schools have been referred to the Commissioner of School Education. Learned advocate for the state respondents is required to take instruction from the Commissioner of School Education as to what are the steps the said respondent has taken on the reference of the respondent number 6. Stop. The respondent number 6 is required to take steps for filling up the vacancies of the school where of which the petitioner is a teacher. Stop. Para. Matter be listed on 28th June 28th. Wonderful. No, call the list.
Similar time for the petition.
Yes, what is the matter about? Compassionate appointment, state.
Then I have to.
Ascertain it from them, not today. Next. Code is same.
My lord, I am for the district primary school council.
Mr. Dhol is appearing.
Yes, compassionate appointment.
Yes, my lord.
Yes.
My lord, I am for the district primary school council.
Lord, kindly come
My
to my lord.
he's a assistant. She was assistant teacher of a primary school. My lord, we have considered his case and found that he is not entitled for the primary school teacher, but entitled for a group C staff of a secondary school. My lord, we have sent all the papers to the DI, district inspector of
Page 28.
My lord, so far, my lord, kindly give me some time, my lord, I have to take instruction about it.
Acha. Evidence service file on behalf of the petitioner be kept with the record. It is now pending consideration before you.
Yes.
The prayer of the petitioner for compassionate appointment is pending consideration before the
respondent
district
number 3.
inspectors for school. See district 24 Pune South. The respondent number such and such hearing. Stop. Mr. Dhol appearing on behalf of the state respondent, raise accommodation to take appropriate instruction from his clients. Prayer is allowed. Let the matter appear in the list on. I think that by 28th you can take 28th of June.
28 June, yes, my lord, 28 June, my lord, kindly fix after any time after that.
Why 28th June?
But 28 June, my lord,
You
I
have
have
zero-
a matter fixed before the division next.
30th June, Friday,
That's it.
30th June. Next.
My lord, I'm the petition in this matter.
There was direction for filing opposition, my lord. I'm praying for extension.
Extension of time for.
My lord, it is regard
2 weeks.
if there is a direction, my lord, if you lord,
Digi, digi,
it's
digi.
only the issue is, my lord, regarding compassionate appointment has been recommended. The lordship sought for a report from the authority. They filed a report saying that she is only eligible for an Urdu medium school. But I stated that you cannot.
That by saying that Urdu medium,
Yes.
they are narrowing
down my
your scope.
And they said I am at the rank 3. Whenever the vacancies will arise, it will be considered. So I said you cannot determine my eligibility on the basis of my first language in Madhyamik examination, because the rule says otherwise. Rule makes a clear classification.
No, this was their impression. Now I recall that sometimes in some schools, Urdu speaking person may be required because they may not be conversant with other language.
Well, in that
is why that is not that it is your qualification to use your qualification for a more better way for the benefit of the guardians and students.
Because first of all, my lord, it's a non-teaching post. So subject hardly makes any difference.
Why?
My lord, no, because
The
it
guardian comes to pay the
speak
fees
in Urdu
or to interact
they
with
will
the
be
school.
conversing in Urdu in the school
Yes.
for exchanging their clerical function. My lord, that is-
Clerical function means you will be in the office.
yes.
So the guardians may come and meet you there.
And speak
They
in
may be conversant with the Urdu. They may not speak, but will not speak other language than Urdu.
That is, my lord, possibly a far-fetched conclusion, my lord.
Not far-fetched, it is happening.
Everybody is speaking in Urdu.
You know, you have seen those who are speaking Bengali outside or somewhere, in home they are talking in Hindi.
Hindi, Bengali, English is, my lord, is different. My lord, Urdu, it is not a teaching subject. So, my lord, that is my contention. And secondly, my lord, the rule says, at the very first, rule 3 makes a distinction. For compassionate appointment, there has to be a separate procedure as per schedule 4, if your lordship recalls in the rule. And so for the regular appointment, it is to be done.
If you got the job in a Hindi Urdu medium, If you have got any, you are concerned about the.
Yes, yes. Yes, no problem.
You are concerned about your
My
appointment.
service. Yes.
They will find out is Urdu school.
Only difficulty is that I may not be kept paying.
They will find out in Urdu school.
Very well, my lord.
Now, my lord,
Only one
so
thing.
far this matter is concerned, না না, একটা তোরই কাজের কথাই হচ্ছে।
আচ্ছা, আচ্ছা, বলো।
Now, my lord, his lordship on the last occasion, my lord, I sought for instruction from the, my lord, Uttar Dinajpur district primary district inspector. What he pointed out is, my lord, there is no vacant post at this moment. Lord, kindly see this. This is the latest report of 12th of June. With due respect, this is to inform you that at present there is no authenticated vacant post of Group C for unreserved or OBCA category in Bingu.
You are unreserved.
OBCA.
OBCA.
Authenticated. Lordship. There may be vacancy which has not been authenticated. You
But
find out
my lord, they have, my lord, I have enclosed those documents, my lord, which they have communicated. My lord, firstly, my lord, last document, 22nd of May, it has been from DPI to all the head of the institution of the schools of Uttar Dinajpur. As his lordship pointed out on the first occasion, all the school, you get hold of this, whether any vacancies is there or not. My lord, in terms of that, my lord, a chart has been sent, my lord, it has been sent by the DPSC along with this, my lord, with regard to this vacancy roster and all these things, my lord.
vacancies are there.
Yes.
But according to them, my lord, so far OBC A and Group C, there is no vacancy.
Oh.
There is no vacancy. Lastly, my lord, another document, the next document of 5th of June, that has been from the DI to the Deputy Director of School Education. My lord, kindly see, in response to the captioned subject and in reference and after getting response from school's end, this is to certify that there is no vacant post under referent caption above till date. This is the latest
You have
position.
to wait. You have to wait. Forget about that Urdu medium. You have to wait. In any event, there is no vacancy at all. Even if you are not classified as a Urdu knowing, Hindu language knowing candidate, but no purpose will be served at this stage if the whole district has no vacancy in Group C.
Group C and OBCA.
Both match.
Both,
Even a
both,
Group
both,
C is not there, then the OBCA categorization or all these things. So you file your affidavit within 2 weeks. Let us
Yes,
see.
yes, yes. My lord, only one humble prayer. In the meantime, if the vacancy arises, let it be considered considering the candidature of the petitioner. That's
Since this
let it be
lordship is
recorded.
in session
Yes,
of
yes.
this matter, my lord, we are tried. My lord,
Let us wait. You wait.
Yes, yes.
Let the affidavit comes on
Yes.
record.
In the meantime, state is open to do that.
No, of course,
Yes,
of
yes, yes.
course.
If it
This is
vacancy
not-
arises.
This is the list is coming on 22nd May 23.
Yes, yes.
Yes, my lord.
There could be, my lord. There are possibilities.
Yes, it
Any
can
day
be.
it can.
Tomorrow.
Maybe we do not know that.
Even today when you are arguing, it may
Maybe,
happen.
maybe.
Vacancy may created.
Tomorrow I may not even.
And are you
ask an
expecting after Panchayat election some vacancies will be created?
That I cannot say, my lord. That I cannot say. I only heard that
On
the number of wickets are being sold in a very large number. That's the only thing I heard from Domtop. 500 in a day. That I heard.
Go there, sell some buckets,
I
additional
come down
payment.
to
Now,
that
now,
only,
my lord,
my
now,
lord.
my lord, those areas, my lord, they are interested in cricket.
And now water pipes also. The next news.
Chalo. On the prayer of Mrs. Dubey, London Council for the Commission, time to affirm the affidavit in opposition to the writ petition is extended for a further period of 2 weeks. Let the matter appear in the monthly combined list of July. And sorry, time to file, time to affirm reply is also is extended accordingly.
এটা একটু রেকর্ড হবে না?
বলে দিচ্ছি।
ঠিক আছে? Matter to appear in the monthly combined list. ওটার আগে এটা হবে না। July. Let us see by
Yes, yes,
July
yes.
when the vacancy.
So far, this part is concerned, kindly record, my lord. Since, my lord,
No, you keep it with it unless the affidavit comes. Let me see the commission.
let it be, because this document has been given to me, let it be on record.
Mr. Basu Malik files. a report of the district inspector of school SC Uttor Dinajpur, respondent number such and such, এটা একটা জায়গায় উপরে দেবে।
চেষ্টা করছি আমি sir.
Regarding the vacancy position in respect of group C candidates under category OBCA. The report suggests there is no vacancy at present within the district in which the petitioner can be accommodated.
Lord, can it,
Let the report be kept with the record.
only one prayer may be recorded, my submission. In the meantime, if anything, any vacancy arises, I may be considered because I have.
Yes. However, if any vacancy arises during the pendency of the present petition, the respondent authorities shall consider the prayer of the petitioner for compassionate appointment against such post.
Grateful to Lord.
Against such post. Against such post. Next.
Might I appear for the
Where is the commission?
I have served my lord upon Mr. Mukherjee, my lord.
Service will not do. Why are you late?
And Mr. Nundi is also here, my lord.
Why are you late? Whole difficulty he is creating. Why
going on? Lordship, I'm for state led by Mr. Prosenjit Mukherjee. I'm for paying short over. Sorry, I'm for paying short password.
You are Mr. Mukherjee appearing for?
West Bengal Madrasa Service Commission.
Where are you taking this institution? For whom you are appearing?
West Bengal Madrasa Service Commission.
What is Madrasa Service Commission? What is the madrasa?
Sub Educational Board.
When you passed out?
2022.
Which college?
Shambhaja Law College.
Shambhaja. Why this madrasa is there? What is the difference between a madrasa education and a secondary education?
Islamic, I think, madrasa is.
Name one degree madrasa offered.
Sorry, sir.
Any one of the academic qualification a madrasa can offer. Under whom you are practicing?
Kunal Ganguly.
Where is your senior?
This is not our brief, sir. This is not our brief, my lord. I don't know the whole matter.
Who advised you to join High Court? Sit down there. You will not be leaving. Sit down over there. You are making the things complicated.
I ought to have come my lord, much earlier, my lord, since my lord, selection process was initiated on 4th May 2023.
What are you doing to this institution? You people make all the things complicated. This was notified when?
4th May 23, my lord.
4th May.
And subsequently on 13th May, my lord, the guideline was uploaded in the website, my lord.
Then why today? What will happen? Mr. Mukherjee, subject to what you say, I think that all employment notification should be routed through NCRT. You may have made some mistake.
So today morning, I have got the brief and immediately I have sent the message to the recruiting body that this is the Fact is 2011, there is
No,
a
Mr.
clause of
Mukherjee,
relaxation.
what is the problem, you know? Problem is this petitioner alone will be getting this advantage. And it will be followed up. Then when he will be, maybe when he or she,
Him.
he will be selected. Then somebody may question it in a repetition. All that, first of all, others will be deprived. Then when he will be selected, one writ petition challenging his, that how he has, then he will be entangled in again in a every employment notice, if it's routed through NCRT, that look here, whether you have a latest notification or anything. Are we
Lordship,
making
this
any?
notification which my learned friend is relying, Lordship, kindly come page 63.
Mr. Mukherjee, you need not take this trouble. 5% relaxation in the eligibility criteria, Mr. Nondi is to say yes or no.
Yes, my submissions, yes, in terms of notification dated 29 July 2011.
Mr. Mukherjee, how it
Now,
can
Lordship,
be?
whether this notification is applicable because 2018 subsequently another notification has been issued. Subsequently, the Lordship, the eligibility criteria for the post of Lordship, the up to class 10 and 12, 11, 12, Lordship 2014, subsequently notification is, that has to be checked up. But Lordship, I have informed that this is the situation, the 5%, the candidate is a OBC candidate and 5% he is eligible. What can be done? Lordship, they are, Lordship, the inquiring this situation. Lordship, kindly fix it Monday, Lordship, I will.
No, Monday is the last date for submission of application. Now, Mr. Mukherjee, you can address his problem individually. What will happen? So many candidates are there and you have to follow the reservation policy of the academic body, and it will be depriving, because ultimately what will happen? Some person will challenge the entire selection process, will be crushed down. Entire selection process will be crushed down. Are you
Lordship, kindly then
ask your client so that 7 days time?
no, Lordship, where kindly this is the situation. Lordship, kindly come page 63. Kindly minimum qualification class 1 to 4
1 to 5.
and 1 to 5, then 5 to 8.
6 to 8.
Sorry, 6 to 8.
6 to 8, where from your 6 to 8?
6 to 8. Now kindly come turnover.
Is what about this reservation policy?
Reservation policy. Now, Lordship, whether this reservation policy is applicable in respect of 6 to 8. I don't know. That has to be verified.
That is no verification. You advise your client properly, because unless he rectifies the employment notification.
6 to 8, up to 68. But our recruitment process is up to 6 to 12.
Up to 5 to 8, my lord, there is a,
what is the notification is for?
My lord, for
Recruitment of teachers,
7,
different madrasas.
Requirements and minimum marks.
My lord,
No,
page
what
49.
he is distinguishing is the present employment is present.
My page 49, my lord, kindly see, my lord. The information guidelines, my lord.
No employment notification.
Well-
He is admitting no 5% reservation is given. Now show me the notification.
My lord, page 50, my lord. Page 49 is for 1 to 4, and next, my lord.
This is
5 to
page
8.
48.
Page 50, my lord.
Page 50.
My lord, selection of graduate teachers for class 5 to 8, my lord.
This is the eligibility criteria you are showing. The employment notification is page 48.
Page 48, my lord.
So this is for classes 9, 10 and classes 11, 12.
Classes 9 to
Will it
11.
not cover?
This is the, I am saying that this is 5% relaxation even 2011. It is up to 6 to 8.
No, my lord, it is up to class 12. Because the other notifications, we have other.
Last thing,
2014 notifications.
clarification is required.
Mr. Mukherjee, what I'm apprehending, today you may allow him as an individual candidate to submit his form. Tomorrow there will be a series of challenge that for non-maintaining the reservation policy, entire notice is bad. So when it has come to your knowledge, then Why not you issue a corrigendum?
Lordship, this is not final because we have not decided whether he is entitled to get any 5% reservation.
No, reservation, if it is not declared, then the last date of filing application is on Monday.
Monday, Lordship, if it is so that 5% reservation petitioner is entitled, another candidate, Lordship, we will again extend the time. That is not problem.
Exactly what? Extend the time for filing. I'm not passing any order. If you feel
Now, Lordship, in restricted to the petitioner, Lordship, Monday, if petitioners, Lordship, we finally satisfy that yes, petitioner is entitled to, Lordship, they get 5% reservation, we will allow petition. We allow the petition.
My lord, page 49 kindly see is also includes 5 to 8. My lord.
now so far petitioner, I am not much concerned. So far the petitioner, I'm not much concerned. I am concerned, I'm apprehensive that tomorrow there will be a challenge by any of the party that this notification is vitiated by not keeping the following the reservation policy.
Which is contrary to NCD correction.
Contrary to the entire selection process will go.
That is that we can.
Can we, Monday is a difficult situation. Monday, Tuesday.
Last day, call. Lordship, kindly fix the first item in the Monday.
Monday, I will not be available. Monday, Tuesday, I will not be available. Monday, Tuesday, I will not be available. So do one thing, take instruction that petitioner be allowed. And in the event you find that petitioner is eligible for relaxation of 5% in terms of the guideline of the NCT, then you may think extension of time and issue corrigendum to the employment notice. Can you do so?
Universal application.
Yes. Otherwise, entire process will be.
Problem is, Lordship, this is not available in the Sartho. They have issued notice to the commission yesterday, and the commission till date has not received it. I received it in the court.
Which one?
This petition. Now that is, I have telephone instructed whether this petitioner can be allowed by relaxing 5%. They are saying, let the petition come. I will decide.
So this instruction I give, but the court is directing you to reconsider the entire thing. Extension of the period of time to file the application and consider whether this can be generally applicable to all candidates. And corrigendum to the notice of employment notice.
Lordship, let there be no direction. We will take, Lordship. If this possible.
Because in another matter,
yes,
I directed the commission to issue corrigendum if they consider so. That the Mr. Nondi pointed out that there was any lapse of following the academic body's circular. You can do that. Yes. Let us meet on Wednesday. What steps you have taken so far?
And last date it on 19, my lord, without prejudice, my lord, may I be permitted to only, my lord, application, my lord.
You will approach the commission. Whom to approach? Commission?
Lordship, the secretary of the West Bengal Madrasa Service Commission.
Respondent number 2.
My respondent 3, my lord.
Lordship, kindly direct the petitioner to approach today so that his application can be filed by Monday. And because we have to modify our system because it's an online application.
Very well. Today you approach.
He resides at Malad, Mushidabad, Malad. May it be by tomorrow, Malad.
Then let him stay over Mushidabad. Let him stay over Mushidabad. Send your junior, rush to Kolkata in whichever mode he can.
আমি ওভার টেলিফোন বলে দিচ্ছি আপনি অ্যাপ্লিকেশন পাঠিয়ে
আচ্ছা the West Bengal
5%
Madrasa Service Commission Wide memo number page 48 dated May 4 acknowledged, but his such participation shall be subject to the result of the present writ petition. Stop. Mr. Nondi, can you say what is the relevant rule so that I can quote it for the general? This is the rule. This is the notification.
In terms of section 23 of RT Act, it has been framed, my lord. It has been mentioned, my lord.
No, this is 60, page 63, the relevant notification. Stop. The relevant notification of the NCT dated July 29, 2011 prescribed
Page 57, my lord.
23rd August, page
57. Page 57.
Record reveals that the notification of the NCT dated August 23, 2010.
Subsequent amendment, 29 July 2011.
That is not for, oh, that is 29/11, yes. And the notification amending the said and the amending notification dated July 29, 2011 prescribed the reservation policy for appointment of the teachers belonging to the reserved categories. Stop. In terms of the said notification, for the candidates belonging of such categories, there shall be relaxation of 5% in the qualifying marks. Stop. The employment notification of 7th SLST 2013. 2023. Page
49, my lord. Page 48 and 49. Important.
Page 48 lacks the such requirement. Stop. Now, lacks such requirement. Stop. The petitioner, therefore, is permitted to fill up. No, the Secretary of the West Bengal Madrasa Service Commission, respondent number 3, therefore, is directed to allow the petitioner to fill up the form to participate in the ensuing selection process. The petitioner, it is however made clear that in the event the petitioner is found eligible, his appointment shall be subject to the result of the presented petition. Affidavit 3 weeks, 1 week, 4 week, final disposal. Stop. Para. The commission is directed to consider whether a corrigendum to the employment notice can be issued for the benefit of the candidates similarly placed with the petitioner, an extension of the time to submit the online application to participate in the said selection process. Stop. Very well, Mr. Mukherjee, ask them to consider. Otherwise, there shall be maybe a challenge. It will again this kind of scam, all these things. Your entire exercise will be futile. Entire exercise will be futile. Extend for 7 days after rectification. It is not that you are infallible. You did because there is a lack of communication. NCT is not communicating with the other bodies, taking responsibility of whole India.
before issuance of this notification, each and every, lordship, the reporting body has to sit with the LCT.
Has to.
Has to.
Has to see.
Obviously, has to.
All states.
With respect to
All this,
states.
yes, all this kind of situation would not have been occurred. Hmm.
You are
Yet-
also suffering by the same, you are also facing the problem.
You try to meet the secretary or your immediately. This order will be uploaded. I will trying to get it uploaded as soon as possible. Eta priority দিয়ে করে আনো।
আমি ফোন করে দিচ্ছি।
1 week, 4 weeks. সন্দীপ এটাকে তাড়াতাড়ি করে দাও এটা এখন তো ল্যান্ডিং ছিল Yes, Mr. Godagoda.
Regarding that child matter.
What is your instruction?
Child has taken admission.
No, that I have heard. What is your stance? Admission to which school?
At Saini International School, Howrah.
No, I understand, but I'm not happy with the conduct of your client. Because it's one part. Child cannot be forced to take out from that school and put in another school. But if she is of things that she can do whatever she likes, because the earlier order was there.
Order was there.
রাখো না,
The child was admitted initially by.
Mr. Gotagrota, every fact is clear like anything to me. What I told you, that this is my prima facie view is a clear case of contempt for not complying. I am not going to execute this order. Contempt is not a jurisdiction to execution of order.
I understand.
If it is ultimately you cannot satisfy me that there was no intentional violation, the consequence will be very dangerous for her. Because she is a lady, she is not understanding what will be the consequence. Make her in sense. So far the child, this is not a thing that she will be unplugged from that school, she will be forced to that school. This is not the way. But you have to very carefully explain the conduct. Still, I am giving her the chance. If she feels that there was a mistake, I would like to amend my conduct. I may give her a chance, but if you try to justify her wrong, then the consequence will not be very happy.
No, certainly not. There is no question of justifying her wrong or
So
something. It
you
is
take
considered
the
welfare of the child.
yes, no, forget about that. Removal of the child, forcing the child to go another school to satisfy the ego of the parties. But she was directed to give the child back to the school. She did not comply. Even her conduct in course of the hearing was not very
That's
pleasant.
why I asked her not to come to the court. Since a
Not
couple of
very
days-
pleasant. So make her understand that I'll not be happy to put her in jail
Certainly not.
or saddle her with a fine of 2-3 lakhs, wherefrom she will be given.
I can rest assure your lordships that there is no willful or deliberate violation of your lordship's order.
Satisfied?
Situation compelled us.
Don't bring it today. Okay. Next week. Put it next week. And the petitioner is not here. What did I go?
36.
This matter, my lord,
I am praying not today, my lord.
my lord, not required, my lord. I think, my lord, not required, my lord, after placing my case. In this matter, report ought to file this matter relating to, my lord, 11-12 selection process. On 28 June, my lord, return all these matters, so they ought to file the report, my lord. It will cover every case.
To publication or what?
Publication in that expert. So, my lord, kindly pass the same order, my lord.
Yes.
We order to cover, handed over for.
No. Let it come on the same. You will require to pass a report.
Well, in this matter, my order passing is required because this matter, although it is my matter, but thereafter passing of the order, my lord, they took NOC from me. My lord. Reason is not known to me, but they took NOC from me.
You are also a waitlisted candidate.
Yes, my lord. My case is that I am a well-listed candidate in the subject of political science. The less meritorious candidate, they got appointment. In page number 6, para 7, I made a tabular chart. From that tabular
from the
chart.
waiting list, no waiting list. Lower rank candidate has been given.
Yes,
Rank jumping.
Rank jumping. And my lord, kindly see the brief, my lord, my writ petition. Page number 7, I made a tabular chart. It is evident from my tabular chart.
Who is the respondent number 7 here?
No, my lord, here, my lord,
A private, no private respondent here.
here, my lord, I unable to make the private respondent because
So now this part will not be there in the
not be there, my lord. But School Service Commission ought to, and my lord, kindly add one thing, my lord. In respect of 28 September order, 2022 order, on which I, in the last occasion,
8 June order, 8 June order.
28 September order, my lord, which I handed over last occasion, my lord, from where it is evident that 907 OMR sheet marks is enhanced, my lord. Kindly, my lord, record that portion.
No, that I will let the report come. Let the report. I want to see how the
Yes.
Where is your affidavit of service?
Kindly keep.
Where Dr. Patro has come. No, Patro is engaged in it. So I'm recording his name also.
It's similar report only covered.
এই দেখো এইটুকু পেন্সিলে ইরেজ করে দিচ্ছি, এইটুকু থাকবে না। হ্যাঁ,
and my lord, kindly erase the Bengali portion. This case is political science, my lord. Kindly erase the Bengali and it would be substituted as political science, my lord. Second paragraph, my lord. The petitioner participated in the first state level selection test 2016
this
for
should
the
be in assistant teacher in political science.
political science. Yes, my lord.
No, এটা করে দিও। 28 all matters.
28 at 10:30.
Wow. No, actually.
My lord, item number 37 is also relating to the same selection process, but here, my lord, earlier occasion, there was a direction to file the report by the School Service Commission. Two times they prayed for extension of time, my lord, but till date they not filed the report, my lord. Kindly keep it also, this matter also on 28, my lord. Last occasion, 13 April, last order passed in this matter. My lord. May I hand it over the last order?
I think
So, Mr. Samim,
Yes, my
the
lord.
problem is, all these matters we can approach up to a level. Thereafter, we have to wait. Because of the what decisions are
Yes, my lord,
coming. and
but we have to achieve that level also, because
Just
the-
tell me, for publication of the OMR in their website,
there
I
is no
think
such hindrance.
there is no.
My lord passed this order now, here and now, because of that, my lord. This is a publication for the sake of fairness and transparency.
No, is there any order of injunction or
No,
right
this
nature?
is regarding 11, 12. There
No,
is-
maybe in 9, 10 primary, whatever has traveled to Delhi, was there any injunction
no.
of this kind?
He kept in abeyance in respect of the service termination by invoking
Only.
Yeah, only. But there is no such stay or kept in abeyance order in respect of publication, because my lord segregate this matter with
But
termination.
those persons are still merrily working.
But it matter will come on 11 and 12 July, my lord. First primary, thereafter 9, 10 and group C.
But the persons are merrily working.
But that is not what
Those
my
who have
understanding.
lost their service.
Yes, my understanding.
9, 10.
9, 10. Yes.
They have joined in the school again.
I don't know, my lord. That instruction I haven't, but my understanding of law is that, my lord, the Supreme Court passed an order to kept in abeyance, not stayed, my lord. There is a basic difference between.
Yes, of course.
Yeah. Kept in abeyance does not means they ought
Revival
to-
of their.
Yes. But somehow, my lord know it better than me, my lord. The administration with them, if my.
Yeah, it is
Yes.
it is a way you can see it half filled
Or
or half vacant.
have-
The way you see that.
Yes. That canvas
Let the matter appear in the list on June 28.
at 10:30.
June
ওই একই দিনে স্যার। হ্যাঁ,
Next one.
38.
Your Lordship, I am for the petition item number 38. I am led by Mr. Sudipto Dasgupta, your lordship. He is appearing in another courtroom, your lordship. Kindly grant me a short passover. After recess, he will appear, your lordship. Before the
Huh? Secondary board. Passover.
your lordship. Yes, your lordship. After recess, you will appear, your lordship.
Sure, Passover will serve your purpose.
Oh. Not today, your lordship. Passover for the day, your lordship. Kindly.
When you joined the profession,
21 November.
what is your name?
Shutirtho Naik, your lordship. Shutirtho Naik.
From which college?
Shyambajar Law College.
Very well, not today.
With regard to that matters, suspended headmaster matter,
Hmm.
I've received telephonic instructions, my lord, we'd like to withdraw and file afresh. Since the point of maintainability was.
At least you are convinced, or
ফর্টি রাখেনি তো, 40 রাখেনি তো, সিঙ্গেল বেঞ্চ বসবে না, তার 40 আছে কিন্তু, তারপর বসুন।
then you prepare, today nothing can be done. You prepare your separate writ petition.
My lord, I'll be needing my lord's leave. I'll have to put the leave in the new writ petition as well, my
Yes,
lord.
by Wednesday, to be mentioned Wednesday, inform.
I shall inform mother. On the cell.
ওইটা না আমাকে সই করাবেন। your writ petition.
My lord, I shall. I apologize, my lord. I'm grateful.
Where is Mr. Prosenjit Mukherjee? What is this? Rondi, see that?
We have been discussing.
B.Ed special education.
That is absolutely.
B.Ed special education, that B.Ed special recognized by the RCI. I am possessing that B.Ed special education qualification, and as per NCT guideline, it is a valid training qualification for 5 to 8 months.
We have been discussing absolutely wrong corrigendum itself.
Well,
Because
5 to 8 is
they are
as per
saying B.Ed
20
approved by RCI. B.Ed
Yeah.
cannot be approved by RCI.
B.Ed special.
Special should be approved by
Yes,
RCI.
this is B.Ed special.
Where is Mr. Mukherjee?
B.Ed special.
This is the employment notification. Entire employment proceeding will, process will be quashed. And see the extension of time. Then
19th June is the last date on Monday, my lord.
If all petitions, if all notifications are on
B.Ed special is a valid training qualification as per NCT guideline, my lord.
they want that this should be challenged. I think that they want that this should be challenged.
এটাই বলছি।
চিন্তা করে দেখবে পুরো জিনিসটা গন্ডগোল করে
my lord. My lord, page 58, my lord, clause 2, last, my lord, BA with at least 50%, 1 year
Page?
B.Ed special education. My lord, 58, my lord. 58, my lord, B.Ed special education.
So you are saying the reservation policy has not been followed?
Yes, my lord. This is
Where from? This is this.
no the reservation policy page, my lord, page 64, my lord, 5%.
Each page. No, these are 5%.
Right.
The employment notification contains that it should be there shall be 50%. Where is that? 50.
My lord, page 49, my lord. Relevant.
You are applying for
My lord, 7th SLST, my lord, I am eligible, my lord, up to, my lord, 5 to 12, my lord.
5 to 12.
50% marks in graduate and postgraduate with 50% marks. With B.Ed, my lord. That was notification. Subsequently, a corrigendum was issued.
Postgraduate concerned subject with 50% marks with B.Ed.
B.Ed. Subsequently, corrigendum was issued that 12 June, my lord, where, my lord, B.Ed special education qualification also incorporated. As per
That
NCT
was after the order passed by this court. B.Ed special education.
On 5th or 6th June.
There is a corrigendum that I indicated to you. This is the corrigendum.
That is itself wrong. No, they will apply the mind.
Great.
লাইটটা জ্বালিয়ে দিন।
এটা corrigendum should be wrong. Either they have to write it down in a B.Ed special
So-
or RCI. Or B.Ed.
Show it to Mr. Mukherjee. No, all the list. Division.
Application item number 1.
My lord, in this matter,
Sir,
I'll just indicate what has
I was
happened.
appointed, let me.
My learned friend was appointed as guardian of a lunatic. Now, that guardian
Has passed
that
away.
lunatic has passed away.
So this is my application for discharge.
And he is asking, I think he has to give accounts and be.
Accounts is ready. I will just, final accounts is ready. I will hand it over, my lord, next week, whatever direction your
Now,
lordship passes.
there's another part to it. The lunatic, in this case, is survived by no one apart from his sister. Now, Lord, whatever he is holding, the funds and other things will have to be directed.
And who will
to
be
hand
the
it over.
guardian of the lunatic?
My
Who will
lord?
be the guardian of the lunatic?
No, he has died. He has passed away.
Oh, yeah.
He has passed away. I was
Passed
appointed.
away. I am the only surviving Lord, heir. There's no one above, below, no one else. Lord.
Sister.
I'm the sister.
Sister of the lunatic.
So this is the
Father has
application.
died,
by-
his son has
By,
died.
I was the appointed guardian by this court
Hmm.
to look after his financial affairs and other affairs. He has passed away, so this is my application for discharge because he has passed away and,
This is an application by you for.
no, by me.
By the
Review,
by the
review,
guardian.
by the guardian. Lord, my learned friend was appointed as the guardian
No,
by
no,
this.
guardian. But whatever, you were a party to this entire proceeding?
Yeah, not the proceeding started before Lord, the Alipur court came up here. In this proceeding, he was appointed by this High Court.
How it has come here?
Lord, there was an order appointing, but there were three people who had applied to be his guardians. One was some promoter, one was Lord, his mother's some relative, and one was Lord me, who is the sister. Lord, on that application, Lord, there was some appointment that not against that there was a challenge. Lord, I'll give your lordship the order. If your lordship takes the review application, it may be in the file. If your lordship takes page 87 of the review application, the order is there. The order of appointment is over there.
Review is defective, out of time.
No, review, no, this is my application for discharge. I don't know.
Yes,
which
sir.
part.
I tell you,
The
lordship.
review is surviving.
Not.
Yes, the review survives. Not on death, nothing will survive. Frankly, Lord, everything will be.
The review is filed out of time.
No. The review was filed already. It was being heard by Justice Banerjee. Then,
No,
Lord,
this is review is filed out of time. This is the report.
there is a section 5 also.
This has been allowed.
My lord, I'm not very sure. It's relating to some time ago. In fact, Justice Banerjee had indicated that he will sort it out, and then Lord, COVID came, and Lord, nothing has happened. In the meantime, Lord, the lunatic has died. I'll just indicate not what the facts are. If I can just give your lordship a chart, Lord, that will.
Very well. The other thing is that you are, what is your name? Name of our client?
Lord, we are Sushmita Basu. Lord,
Sushmita Basu.
can I just give a chart which will make it clear? Lord, it will be easier for your lordship. Take it. Just to make it easy.
Yes, passed.
Now, Taposh has passed away. The date of death is given. Lord, I am Sushmita, who is in the middle. Now, Manosh is the one, Lord, over whom my learned friend was appointed guardian.
He was the lunatic. right.
He was the lunatic. Now, he was married to Amrita, who has also died, Lord, earlier. They had a son, Pronit, who has also died in 2017.
Right.
There's no one left, not other than me now. Lord, one of the strange things in
He
many
was
families.
declared lunatic in a proceeding.
Yes, I'll just indicate. Not in some families, I think not. It's a defect.
Long
If
time.
your lordship sees on the left side, Taposh was declared a lunatic. Then Lord Manosh,
It was a family trait.
it's some family trait, I suppose. Lord, it's one of those things which originally, Lord, his wife was the guardian, Amrita.
Where is the discharge application?
What petition, sir?
আঘাত তো উচিত আছে, কিন্তু
She can too. My learned friend's application should
No,
be can.
a very short application, 2-3 pages.
But it should look like this, not
Very short application.
এরম দেখতে। আপনাকে দেবো সুবিধা হবে আপনার বার করতে। Can too.
না, অত বড় হবে না।
ছোট। না, অত মোটা না।
Maharaj,
Filing slip, in which court you filed that application?
that I do not know. It has been filed in the department, but I don't.
You must be mentioning the court number. They have to trace out the application.
It's not there, then I'll find out. Maharaj. I'm not too sure.
But
advocate-
what I'll do is I'll get my advocate.
My advocate on record, his father is in the ICU, so I couldn't get it. I don't even
Ask
have.
your advocate on record to come to meet my officers, our officers,
Yes.
and supply particulars, they will
Yes, yes,
trace
so
out
that-
the application.
Very well. In the meantime, I will file my accounts as well.
Yes,
whenever
you bring
lordship
your
thinks.
accounts.
Yes.
And what remains then?
Lord, three things remain. Lord, one will be his discharge, subject to filing of accounts, I take it. And Lord, he'll have to hand over the whatever is left of the estate to Lord, the only surviving relative, which is my client.
Then you have to bring some affidavits or other way around.
Already on record. It's on record in
He
the.
is the only surviving heir.
That's already on record. Lord.
Already on record.
Already on record from the review application, which is in your lordship's file. Only the fact of subsequent death was not there. That is there in my learned friend's application.
Yes, yes, I put the.
Yes, put the death certificate and other
certificate.
things.
Only, the time I was appointed guardian, during that period, I was operating a bank account, some payments had to be made. Other than that, whatever the properties I have, they would have.
Lord, earlier there
particulars.
may have been some contentious issues, but on death, Lord, nothing remains. Nothing remains now.
I have this account which
The
is.
review application.
I'll tell you, Lord. Now, Lord, the Alipur court had appointed Lord joint, Lord. If your lordship Lord takes page 87 of the review application, I'll indicate, Lord. Lord, three different applications were made by three different people claiming to be appointed guardian of the lunatic. So the court had appointed Lord someone, Lord, on an appeal before this court. The court said, look, remove all of them and appoint a learned advocate as the Lord guardian. That's what happened. Now the review was filed. I'll indicate why. Because one of the appointees was removed, Lord, on the ground that there was an adverse interest, so that person should not be the guardian.
How do you
So-
react on this observation of the division bench?
Yes, Lord.
In such circumstance, the court below ought not to have appointed Sushmita as the guardian,
Yes.
where Sushmita would be in a position to compromise Manoj's
Correct.
interest in the probate proceeding and obtain undue benefit of the virtue of her position as
Correct.
guardian.
Now, Lord, what we have said is, Lord, the review petition, in fact, indicates that he had no interest adverse to that of Manoj. That's what the review is. But today, all that is not necessary because Manoj has also died.
Yeah, that I agree. The only living.
What is the
relative-
will about?
My Lord.
What is the will about? Probate case about?
No, that's nothing to do with this. That's nothing to do with his will. It has nothing to do with it. Not again, not if your
What is the
lordship would
probate
take.
proceeding?
I'll
Has
tell
been-
you, Lord. If your lordship takes this chart, I'll explain to your lordship. Now, Lord, if your lordship takes this chart. Now, what had happened was Pradosh Bajpayee, right on top, not the grandfather. He had left a will, my Lord, by which some property went to Taposh, who's on the extreme left. Now, he has died a bachelor also. So today, my Lord, on death of Manoj, it really doesn't matter. It again, Lord, with him, without him, either way, with or without challenge to the will, it all comes to
Reverts
Sushmita.
back to-
It all comes.
reverts to-
Today, my Lord, all of that is irrelevant because everyone has died.
All comes to Sushmita's hand now. Really, that is the bargain.
There is no one left and there is no dispute about that.
Very well.
Seven.
You bring all these things?
Yes,
in
I'll bring my
meantime, the
accounts back. Yes.
application will be traced
Yes,
out.
Yes.
And
By that time, definitely we'll trace it. Great.
the application in parent number such and such is not on record. Let the said application be placed on the list on July 7, 2 p.m. along with the application for review. Review the infectious disease. Okay, great. No, I'll
this matter before Justice Basu. What happened, my lordship knows, during seasons of the matter, they stopped the pension which has been released for me for last 5 years. Immediately I came before this honorable court, your lordship passed an order on 2nd of February 2020.
And I guess we remember.
With the direction upon the officer general manager to come before the court, why the pension has been released. That interim order staying the operation of the stay of pension has been limited here. Taking advantage of non-availability of the bench, we could not extend the interim order. From March, entire pension has again been stopped. This is very unfortunate, my lord.
Yes,
Then
Mr. Ghozal.
I have to take instruction.
Instruction.
Because after a long time, my lord, the matter come, he never intimated me regarding this.
We have given letter to everybody. And I have possibly my junior has also intimated him. Kindly see the order, my lord, just.
Already the matter has, my lord, had several locations, my lord. We are filing our argument, written notes, my lord, kindly dispose this matter.
First an order, my lord, directing them to release the pension and arrears first, my lord.
Hey, trial court briefটা কোথায়?
Review. Review 72.
Written notes also জমা করে।
Submitted or notes about.
What was his favorite? To this finding of the learned single judge, there was no legal infirmity as regards competence of general manager to act as the disciplinary authority in respect of the scale 2 officer on the day of final order was passed. Right?
May I give my response? My lord?
Yes.
General manager, if pass the final order, then I have to prefer an appeal before the.
That I understand. Your problem is general manager's
When
appellate
assumed the
authority.
charge, he was not the disciplinary authority. When he assumed the charge, at that particular point of time, chairman was the general manager, rule has not been changed.
No. General manager was competent to.
And on the date of passing order.
On the basis of 2013 rule.
2013 amended.
Regulation. Amended regulation.
Before amendment of the rule, while chairman was the disciplinary authority, general manager assumed the charge and directed me to submit my reply to the report of the inquiry officer.
No, first of all, this situation was taken note of by the learned single judge.
And learned division bench came to a finding.
No, I'm coming. So therefore, this was your challenge to the penalty imposed as well as the entire disciplinary proceeding. This was the ground of your challenge, that general manager cannot assume the charge of a disciplinary authority under regulation 2013 at that point of time when the rule was not come into. Right, this is the one challenge to you. But the learned trial judge has returned a finding on merit.
On the date of passing order, rule was amended.
As on the date of the passing of the order, he got the power, therefore it is not vitiated for.
But the learned signature did not deal with the provision to whom I shall prefer the appeal.
Now the next question comes. Since charge sheet was issued by
Chairman.
chairman,
He considered the charge sheet and my reply thereafter directed.
No, understood. Now, under the amended regulation, he is my appellate authority. Now, if he was the, rather who issued the charge sheet, he cannot be the
Appellate authority.
appellate authority. This has been returned with the finding that there is no same person there.
That's possibly, my lord.
No, this is that. Wrong, assuming wrong. Now, the appellate authority on the same tune, almost in the same tune, concluded.
Now,
But some liberty is given that in terms of prayer B, you file your show cause to, which you failed to.
As I understood.
Penalty was imposed ex parte, in fact. Right? That
my
prayer B, what was the prayer B in the writ petition?
Wash and set aside the. Edit in the nature of mandamus do issue setting aside or was the order of punishment bearing.
Order of punishment was set aside subject to the condition that you are filing your show cause within certain time. Right, in both the cases, right, the trial, single judge and the division bench, both.
Ordered portion is same, just omit.
I'm coming to that. Both considered your case, what you have made. They have assessed it in their own way. In review, we are not going to reassess. Possibly you will not be asking for that. Only scope of yours to demonstrate that, as you are saying, that the entire order is in my favor, but ultimate operative. Then, in one word, that the conclusion is not agreeing with the reasoning.
Contrary to the reason.
Rather contrary to the result. That you have to demonstrate to me. Because we have gone through that. Practically, we did not find out that. It is your task now, at least to don't repeat anything now. Just point out that where is that? Because we are not going to reappreciate this.
Absolutely.
That the same
Your
with
Lordship
the
cannot.
appellate.
Your Lordship cannot.
Right.
Your Lordship, kindly take up the judgment from the review.
Yes.
From first page of the judgment, I am not relying. My submission has been recorded. Kindly come to page 2.
Memo of review, find out memo of review.
Page 13. Okay.
Review number 72.
Review.
Copy of the judgment. But kindly take up the second page of the judgment. First, yes, my kindly turn up the second paragraph. A letter has been quoted. I am not relying on the same. Kindly turn up the third paragraph. His client by letter dated so addressed to the chairman said entirely as follows. Have a look at
that is your submission.
Then next paragraph. He submits there was no response from the chairman or from the bank. His client did not accept the general manager as a disciplinary authority and thereafter did not participate in the disciplinary proceedings. Then he refers to the notification dated so that has been quoted. Mr. Swanson rises judgment of the Supreme Court. Then, last paragraph of page 3. Miss Rao, learned advocate, appears on behalf of the respondent bank. She relies on improved order to submit reasoning given therein clearly inputs knowledge of the so-and-so of the general manager, assuming so-and-so. Last 3 lines. Miss Rao, whether there was any reply or explanation given to appellant on why the general manager assumed capacity of disciplinarity, nothing was shown to us. So, after assuming the charge, I wrote a letter to the chairman. Don't allow the general manager to act as a.
This is also factual.
No, that has been accepted by the bank. No reply has been.
It's a fact that he has not replied. He is not saying that we replied to you that.
That time, they will not find at the time. There is
That
reply.
was replied.
Yes, there is a reply, but.
Yes,
earlier advocate
then
has-
show your new term.
Findings, just findings. Page 4. One line.
Here we have a situation.
Here we have a situation where non-compliance with requirement of the regulation in place have been demonstrated. At a time.
Wait,
when
wait,
amendment-
Mr. Shara, wait. Here we have a situation where non-compliance with the requirement of regulation in place have been demonstrated. What does it mean? It means that regulation in place means when the
charge has been assumed,
charge sheet
general manager was
issued-
not the.
So first of all, charge sheet was issued by the chairman. The regulation in place authorized the chairman to issue charge sheet. No problem. Under the 2010 regulation, chairman was the authorized, right? Now, non-compliance with the requirement of regulation in place have been. Then tell me what stage you are understanding from this expression.
This is at a time when amendments to the regulation as proposed, awaiting notification, etc., were neither made known to appellant nor published do have to come into effect.
Then
just pausing for a moment. So when the general manager assumed the charge, regulation has not been amended. That's the findings. Observation. That's the findings. When general manager assumed the charge, rule has not been
Division bench,
amended.
you are interpreting this expression.
That's the second paragraph. Again, I am reading. Here we have a situation when non-compliance with requirement of the regulations in place have been demonstrated. I have demonstrated. Then, at a time when amendments to the, I wrote a letter. At a time when amendments to the regulations as proposed, awaiting notification, etc.
When the notification was issued,
my lord, just I am giving the dates. Can you take up my notes of argument? Very short form it has been given. Charge sheet, may I give dates, my lord? Can you take up my notes of argument? Division bench says when I wrote the letter even
3rd May 2013,
general manager claiming himself as disciplinary authority.
Assume charge.
Yes, assume the charge. This
Now,
15th May 2013 has been dealt with and that
service regulation amended.
Prior to that, your lordship kindly consider 15th May 2013. That has been dealt with in that paragraph. When challenge has been made, rule has been not been amended. That was the conclusion of the division bench. 15th May 2013, I challenged the authority of the general manager. While the rule has also not been amended, that has been dealt with in that paragraph.
Then 20th November 2013.
Yes.
Amendment made prospectively.
So, my lord, the judgment of that, if your lordship allow me to read, now it will be clear to your lordship. Here we have a situation where non-compliance with requirement of the regulation in place have been demonstrated. I have demonstrated. Means I wrote a letter. At a time when amendments to the regulation as proposed, awaiting notification. When I objected to, even at that material point of time, also rule was not amended, etc. Where neither made known to appellant. I have not been given any information that it has been we are going to, nor published to have come into effect. This is entirely in my favor. Then judgment has been dealt with. Next paragraph is more in my favor. The rule-making power and the recruitment rules made by the administrator were validated. Here no rule was made, but action taken. Kindly pausing for a moment. Before making the rule, steps have been taken. Here no rule was made but action taken, not in compliance with the rules in place. Rules in place was 2013 pre-amendment rules. Here no rule was made but action taken not in compliance with the rules in place. Appellant's conduct was consistent. Consistently, I wrote, General Manager, you cannot do it. With the stand taken by him insofar as he desisted from thereafter submitting to the jurisdiction of the General Manager. I have not accepted to act as his disciplinary authority. Facts in this case do not record so and so. So the entire findings says when General Manager took charge, he was not in a position. When I wrote a letter, he was not in a position to act. No reply. Division bench entire findings in my favor. Today, reality says after 8 years, I cannot participate in the disciplinary proceedings. It is another aspect of the matter.
That is on merit.
I'm not coming.
That is an erroneous, maybe an error.
Yes. But kindly see the entire findings. Your Lordship, no civil procedure court says first discussion about the facts, then findings, then conclusion, then judgment. Judgment should follow the observation and findings. I have relied on judgment in my notes of argument also. Judgment cannot be contrary to the findings. Judgment cannot contrary to the findings. The entire findings, only operative portion is negative.
Decree must agree with the judgment.
Well,
Decree must must agree with the judge.
but that judgment I have also relied on. But Your Lordship, so this participants I should not make. I'm not there, so there. So, but kindly consider this is the point for review. I'm relying on the civil procedure code.
For what? Both of
But
us
then-
on the civil background.
No, I have just gone through. Kindly see, my lord,
Wait.
one judgment.
Make the direction since as on the date of regulation 2010 stand amended. We have also been informed that there was a change of personnel. It is in the same way in on merit again.
Then what is
In
the
office of-
finding? Then just I'm asking myself. The findings is contrary to the findings of the learned single judge. The findings, entire findings is contrary to the findings of
It
learned.
is on merit. It is scope of appeal, not review. Now, what you are showing that if this direction ends here, the justification coming is the later on. We have also been in this. We make direction, say we make the direction since as on date the regulation 2010 stand amended,
On the date of delivering the punishment order. Yes.
even as on date,
Yes,
date of judgment.
yes. Because that amendment.
2010 amended, what is the situation? This is the chairman is the appellate authority and the general manager is the disciplinary authority.
Just I'm clarifying the position. That rule was there. Up to clerical cadre, general manager was the disciplinary authority and chairman was the appellate authority. Subsequently, it has been amended. So far the scale 1 to 4 is concerned. General manager now became the disciplinary authority and chairman is the appellate authority. So these categories of officers has been introduced as general manager is the disciplinary authority. I was a scale 2 officer. So I became within the jurisdiction of disciplinary authority of general manager. That is the only amendment. That is the only amendment. But my proceedings initiated before.
Again, then you are stepping to the merit. Now here,
I'm not a merit.
no, Mr. Sarai, please come to that. we make the direction, this is the justification of the division bench. We make the direction since as on date of regulation 2010 stand amended. Therefore, as on this judgment, 2010 regulation has been amended, 2013 has come, under which chairman is the appellate authority, and this is right, wrong, we don't know. We are on review. We have also been informed that there was a change of personnel in the office of the chairman, and as such, appellant can have no apprehension of the person being appellate authority who had issued the charge sheet. We have inquired, that have been informed, the appellant has scored. Very well. Now, these two logic, ultimately logic is in tune with the logic of the learned single.
Absolutely. It is confirmation. I can say, my lord, confirmation of the property portion of the judgment.
But as this is a finding on this, on merit, that this is why. Now, as you are broadly demonstrating.
Sitting in a review bench, what is the right? My first and almost question is that whether a judgment can be treated as judgment when it is contrary to the findings of the observation. I am only on that. It is not at all a judgment. Judgment should follow the observation.
Does it come within the scope of review?
That's the review. That's the scope of review. It is not at all a judgment. A findings should follow the judgment. Rather, judgment should follow the findings. And kindly, the reality kindly consider.
It's a very good question in a second appeal, a substantial question of law. That judgment is not agreeing with the decree is a pure question of law. That when judgment does not agree with the decree or decree does not agree, it is vice versa. But it's an appeal.
This is not a, this is a review. This is a review.
Yes, bring it within the purview of Order 47. Bring it within Order 47. Free, we are free.
That I have
Bring
already,
it within 47.
I have already disclosed.
Now it has been crystallized.
In my notes of argument, I have given a judgment in a review case.
Show me. Show us.
Yeah. The definition of judgment has given, then
Parent of the case of the record can be dealt with in a review application.
Well, this,
But this is
absolutely
an
review,
erroneous judgment.
unless there is a error apparent the face of record, I cannot come.
This is not error or apparent on the face. This is an erroneous judgment made.
I am saying, well, this is error. Why I am saying so? Just
No, you can go over there.
Well,
that this what you are trying, that this is not agreeing. I given you the
scope of the review.
So yes,
error on the face of record. Scope of the review.
Apart from that, what you are trying to demonstrate that the Honorable Division Bench has formed this opinion. This is the logic, but this is the conclusion, which are not agreeing with each other. Right? Now let us assume that this is your case. And please satisfy us.
Where is the error in the face of record?
No. Please satisfy us that it comes within the sweep of Order 47.
But if I can show your lordship that it is an error on the face of record, then it covers the review board provision. I have to show before your lordship whether it is error on the face of record or not. But a court's judgment is a court's finding is a document.
Yes, carry on, please.
Court's document, court's judgment, court's finding is always a record. The first part of the judgment up to observation, it is a record of the court. If it is a record of the court, my lord, error on the face of record means, my lord, this record does not follow the judgment. It is error on the face of record. The record says general manager has no power. The record says chairman is the chairman, is my disciplinary authority. But decision says no. Chairman can take a chairman can act as a disciplinary appellate authority. General manager can. But
that has been explained, whether rightly or wrongly.
No, subject to lordship, I am on error on the face of record. Just finally consider this aspect. A findings of a court is always a record. A findings and observation of a court is always a record. So, my lord, page 4 up to last paragraph is a record. From this record, it does not say that this has been considered, this has been taken note of. This is error on the face of record. it does not appear that the conclusion part follow the records. If it does not, the record has been produced before the court, that is the findings. If the court does not follow the record, contrary to record, this is an error on the face of record.
Huh?
Yes, if I produce a document, but as I understood, my lord, a record has been produced that has not been distinguished, admitted. If the court do not follow the same, if the court do not take cognizance of the same, this is an error on the face of record. Observe up to observation part, it is an record. It is a record. Court document is a record. Up to from page 1 to page 4, last but one paragraph is a record of the court. If it is a record, and if it is not followed, if it is not taken note of, if it is not been followed, then this is an error on the face of record.
Volume 1. Civil, Code of Civil Procedure, Volume 2 টা কোথায়? খেয়ে ফেলেছো? দুটো দুরকম বই কেন? ঠিক আছে।
Yes. Interesting.
খাতা বই নিয়েছো? তুই যেটা বলছিস এটা নিয়ে আসো। তুই যেটা বলছিস এইটা Anywhere in your application, you have stated that no appeal is taken out against the order under review.
I've helped.
Anywhere in your application for stay or anywhere, have you stated that no appeal is taken out against the order under
Appeal was
review?
taken out. Yes.
Because it is a requirement under order 47. Find out.
After going through your lordship asking me, my lord.
No, not that. I may miss it. I may miss it.
Just after going through your lordship asking me.
No appeal is
Because you
order
accept
47
application.
requirement.
Just- Review PTF application আছে
Reasoning.
application application just application
Or is it review?
Already, well, I am submitting.
What you are submitting? We are on review now. We have heard so long, we have learned.
Well, I am going through the order 47. Well, only thing,
Yes,
well,
you
there
can
is
say something.
no,
The first objection,
my
the
lord.
first objection you ought to have
Well,
taken.
there is
Now at
no
the
new
end,
discovery, my lord, and nothing, my lord. No, there is.
that is a requirement. Not even stated anywhere. There no appeal.
after
No appeal is preferred.
yes no appeal is prepared.
Why?
Report
What
is
is
that
Mr. Shara is saying? Where is that?
it is not the response case for the respondent also.
Maybe-
The appeal has been prepared.
Maybe.
But so far, my lord, one sees
Now, don't go that. I will take you that. I am restricting your view to one A only now. I'll be taking you that. You cannot maintain even a review application.
But no. This is a ground.
Of course, this is a statutory requirement, Mr. Saharai.
I cannot
Ask them to learn. No, not now. Obviously, this will, but
part is law is concerned, I am very novice, my lord. I
Mhm.
must agree. But at the same time, my lord, my specific cases that I have filed a review application. This is not case of either of the parties that there is any appeal. And my case is that no appeal lies. This is
No.
error on the face of record.
no appeal lies means ultimate conclusion is against you. So you have a right of appeal.
Well, so far my knowledge goes, my only duty to show before your lordship, there is an error on the face of record. My concrete submission is that
Mr.
from
Mr.
page
Shah-
1 to page
Mr.
4.
Saharai, when there are two remedies available,
I
supposing,
think, my lord, there is no other remedies available.
supposing in a case where an ex parte decree is passed, you have a remedy of two ways, setting aside the ex parte decree or an appeal. Only rider is if the appeal is dismissed, then the setting aside application will not be entertained. Now here, against the original order of the division bench, you have a right of appeal. And that is why the requirement of order 47 rule 1A is you must ever that there is no appeal preferred.
Any person considering himself aggrieved, A, by a decree or order from which an appeal is allowed. All right, madam. But from which no appeal has been prepared.
This
But
is
it
this.
should be averted.
Yes, of course. How from the court will know? How the other side will know? That I have not preferred any appeal. I am seeking the review.
I have to go through the all documents. I have not gone through
It should come under an
the application. I have not gone through. I have to see it. And there is a supplementary application.
The require why that provisions of order 41 mutatis mutandis will apply in order 47. That is why the memo of review, limitation and all the things. Now, a stay application or whatever, stay or any other similar type of really injunction, you have to avert that this is not. This is a technical point. Of course, this is a technical point, but essential technical point. Because, one is pursuing appeal and another is assent the same time.
This is a review petition. Only grounds are required to be placed before your lordship. Only grounds. There is
No, in a case where discovery of new document, which was notwithstanding due diligence, was not within your knowledge, can be a good ground for review.
Yes, but this is not my case.
This is not your case.
There is no
Therefore,
discovery of new document.
therefore, as you are harping on error apparent on the face of record, what is error apparent in the face of record? That this is the finding and this is the conclusion, which is not agreeing with each other.
So there is,
Right.
But is there any scope to make any amendment in a review application?
You have possibility.
There is no scope for any statement, as I understood, only grounds.
Then memo of appeal, at the foot of the memo of appeal, requirement must be complied with.
But in my review application, I have taken the points that this is the points.
So, Mr. Shara, the requirement of 1A can be fulfilled if you comply with this order 41 format. The provisions of the form preferring appeals shall apply mutatis mutandis to the application for review. Very interestingly, it has been classified as an application for review, not
review application.
Since Rule 3 mandates form of appeal. So usually it should be in the form of memorandum.
Yes.
And
Yes,
if
in the
you
form of
see
memorandum.
that judgment of Justice Vijitendra Mohan Mitra, a single bench judge, that this should be in the form of memorandum of appeal.
That has been done.
Now, in a case to comply with requirement of 1A, you have to give a note under the foot.
Consideration. There is no scope for any affirmation.
1A, assert, write it down, no appeal has been preferred.
Financial, this is a
At the
statement.
foot of the appeal.
This is the statement.
Of course.
I have to affirm it.
Not that, assert it, Mr. Shara is taking the responsibility.
But this is a purely technical ground. Your lordship kindly take it pure technically. This memorandum of appeal. This is a memorandum of appeal. What I to say, this is the judgment, for that I am agreed.
Mr. Shara, supposing in a case where a party dies before the delivery of judgment, but after the conclusion of argument.
After conclusion, before delivery.
No order 22. Then you will be preferring an appeal of the heirs, where you will be inserting the fact where there is no application is necessary at the foot of the memorandum. This has happened.
I'm just asking. I have no. Then I have to file an application for
No, certainly not. Certainly not. Only requirement is at the last page, bottom of the memorandum. You have to insert the requirement of this. Only a statement. But whether your read procedure, if the read court will be following it or not, that to you.
Your lordship knows. Definitely, my lord, CPC will follow. But these are read proceedings.
That is why this is made easier. But this 1A requirement cannot be obliterated or cannot be avoided by saying, because the consequence is there.
Well, the rule says No appeal preferred. No appeal preferred.
Where from I will be getting it?
From me? From me, my lord.
Nothing on record.
There is no record that any appeal has been preferred. There is also no record that any appeal has been preferred. Negative principle. This is not the case of either of the parties.
Not in.
Had my learned friend came with a plea that after filing the appeal, I'm coming with a review application, I could have understood.
Mandate of Code of Civil Procedure is to be followed in the manner as has been stated.
This is a ground, my lord.
Even as smartest
I shall
judge
go through
cannot
my stay application. I have not gone through, there is an supplementary application, but for that reasons, my lord, judgment cannot say, possibly, my lord.
Yes, henceforth, please be careful about it.
Your worship knows, I have never.
Be careful about it.
I have never.
Now, question is, you have to bring it within the purview of Order 47. That this is the situation when the judgment is not agreeing with the ultimate conclusion. It comes within the purview of Order 47 as it is an apparent on the face of record. Please satisfy to that extent only.
Well, I pass
And would you-
for the pension part is concerned. Please start with after 6 years.
Pension part you inquire.
But you also kindly pass on. You
No, no, not on, the already,
your lordship has already passed an order.
you
Already passed an order.
you bring something on record, you write it to him.
My lord, he
You
never
write-
write to
I
something
wrote
to
a
me.
letter to the chairman.
You write it to the advocate concerned. That client is being represented.
No, they have the
By it.
justification. Why I'm
By-
saying so? Kindly see the order. They have the justification. They have given the justification. Kindly see the order. Just I'm handing over to your lordship. Just 1 minute. This is the order. Kindly see. Why? they
Mr.
have-
Ghoshal, take up the issue with the.
Kindly see the order. Your lordship has passed staying the order of withholding of pension for a limited period. Taking advantage of the same. Kindly see the last paragraph. Your lordship called for the general manager. See, they are saying interim order is not there today.
My
That's
last-
their issue.
Learned senior friend, my lord, last 3 months, it happened, not a written, not a single letter to me, so that I can take instruction anything.
For a reason is there, I am not extending or refusing his fare. I am leaving it for him to, he will take the matter with you and you give your
My-
appropriate direction to this.
My lord.
Don't compel us to make
No, no, my
a
lord.
sitting for this matter only.
My-
It will be concluded very soon. Only something I require from, we require from Mr. Shaharai
My-
regarding the ground of this review.
Only thing, my lord, but otherwise everything is.
It will be for 1 month or 2 months only. Since you have sustained so long, so you will judge it on merit.
15 I'm getting the pension.
No, 2018 regulations came, how 2015 you get it, pension?
The
80
moment I
regulation came,
retired,
regulation came in 2019, 18. After judgment.
pension part is concerned, your lordship give some indication.
এটা
Some
আগে
indication.
এটা 1 নম্বর, ওইটা 2 নম্বর। ঠিক আছে? With the issue. We'll remember, don't think that. Further reading, 7 July.
না, আমি একটা চিঠি দিয়ে দিচ্ছি ওদেরকে।
Ready? The client has come. The only issue is whether he is in contact with you or not. You will never. He's still in the other party or he has joined to this party.
I've met him once.
7th July.
7 July, 2 p.m. 3:30 বেজে গেছে তো। 7 July.